Well, good morning, everyone. Thank you so much for being with us. My name is Brian Bird. I'm an assistant professor here at the Peter A. Allard Faculty of Law, and it's such a joy to have you here with us, both in person and online. We're both here in person and on Zoom for this conference on Section 1 of the Charter. I just want to offer, as a member of the faculty, a word of welcome to all of you, especially for those, if it's your first time here at UBC, perhaps, maybe your first time in this wonderful building. We're so lucky to have this beautiful building, this beautiful room today, and I welcome you to UBC, to these beautiful lands of the Musqueam people. We're just so lucky to be here, and we are so glad that you've taken the time to join us either in person or virtually. And I just want to say right off the top, something that maybe one would say as an organizer of a conference at the end of the day is to, first of all, to start off by thanking all of the speakers who have accepted our invitation to join us today. I've had many people tell me in the lead up to this conference that, what a great lineup you have. And I feel a bit odd responding to that, because really that's a testament to the generosity of the people who have accepted the invitation, and not so much, I just send the emails, and they say yes. So I want to start off by saying thank you from the bottom of my heart to all of those who have not only accepted our invitation and prepared for this conference, and I'm sure are going to enrich us today as we speak about a very, very important part of the Charter in this 40th year of the Charter. So there's much more I could say, but in the interest of keeping things moving along right from the get-go, it's a privilege for me to hand over the mic to the Executive Director and General Counsel for Christian Legal Fellowship. Christian Legal Fellowship is the banner under which we are operating today for today's conference, their annual conference on law, religion, and human rights. So please join me in welcoming Derek Ross.
Okay, well, good morning, everyone. And it's great to see so many of you here in person. And we know we have over 100 people also joining us online. Welcome, great to have you online. And we're really excited for today's program. As Brian mentioned, I'm Derek Ross. I'm Executive Director and General Counsel of Christian Legal Fellowship. And we're just delighted to be supporting this program today. This is CLF's 5th annual academic symposium. And it just keeps getting bigger and better every year. And we're so delighted to have so many of you with us. As I'm sure you've seen, we have an action-packed schedule today, and we're delighted to have so many participants with us. At the heart of this symposium, and at the heart of Christian Legal Fellowship's commitment to the symposium, really is a reflection of CLF's belief that every person possesses inherent human dignity, made in the image of our Creator. And respect for that dignity is of foremost importance. And that is the work of human rights law, where we must both protect that human dignity through the protection of human rights, and also account for our duties to respect the rights of others. As we will hear today, how we understand the others to whom we owe those duties is very important. Do we view them as the other? Or do we view them as our neighbors? Or as fellow members of the human family, to borrow language from the Universal Declaration of Human Rights? Or do we view them also as fellow bearers of the image of God, to borrow language from some of our faith traditions? Already we see there are multiple approaches that many of us might have to how we understand human dignity and human rights. I've shared a bit about CLF's background, but there are many other perspectives on human dignity and human rights, many of which are reflected on the panels and in the audience today. And we welcome and appreciate that fact, because our goal is not to promote any one conception of human rights, but to recognize our shared commitment. And our shared commitment today is to work collectively to determine what justice requires in terms of how we can best respect human rights in a free and democratic society. And that's a lofty task, it's an important task, and that's precisely what the words of Section 1 invite us to partake in. How to best protect human rights in a free and democratic society. So of course, everyone's memorized the text of Section 1 by now, right? In preparation for today. But the words of Section 1 read that the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. We will be parsing these words throughout the day today. And some of you might think, of all the sections to examine, Why Section 1? Surely of all the provisions of the Charter, it is the most scrutinized and the most examined, and the one for which the most ink has been spilt in our jurisprudence to date. And it is true, of course, that Section 1 has generated extensive academic and judicial commentary. And yet, 40 years after the Charter arrived and 35 years after Oakes, the first Supreme Court decision to interpret Section 1, a number of elements of this provision have yet to be fully discussed and examined. For example, we often think of Section 1 as our limitations clause, but as you can see, the subheading for Section 1 describes it as the guarantee of rights and freedoms. Early case law referred to this function as being an activating function. That the Section 1 clause has a dual function of both activating and limiting human rights. So what does it mean to guarantee or activate a right or freedom in a constitution? Have we become too focused on Section 1's limiting function and not enough on its activating function? At the other end of the text of Section 1, the concept of and the meaning of a free and democratic society has also received little attention. One of the few instances in which this concept was discussed was in Oakes, where Chief Justice Dixon spent some time exploring the requirements of a free and democratic society. In fact, in that case, the court noted that this was the ultimate standard against which limits on charter rights and freedoms must be justified. And yet since then, this concept of a free and democratic society has rarely been discussed or considered by courts. What then exactly is a free and democratic society? What are its essential ingredients and requirements? That's something else we look forward to exploring today. And there's also merit in pausing to consider whether the leading legal frameworks for Section 1 set out in Oakes and Doré require any type of refinement or recalibration to better align with Section 1's full text. Both texts arguably have shifted the focus away from certain aspects of the text and focusing instead on the idea of proportionality. Does that need to be re-examined? So these are just some of the themes that the symposium will explore today. We may disagree. I'm sure that there will be many things which we agree on and many things that we disagree on in our discussion. That's okay. In fact, that's a good thing. It's only by engaging in these discussions that we can sharpen our own perspectives and perhaps recalibrate them if necessary. So we are so grateful for our time together today. We want to thank you for being part of this gathering. We especially want to thank the Peter A. Allard School of Law and the Social Sciences, Humanities, and Research Council, who have provided funding for this project. For those of you that are watching or partaking online via Zoom, we really want to invite your participation. You'll see there is a Q&A box at the bottom of your screen. We invite you to use that to send comments or questions to our panelists and speakers. We'll be collecting those and presenting them to the speakers throughout the day. Also, for those in the room, we have a special email set up. If you want to send email any comments or questions throughout the day, you can do that at section1symposium@gmail.com. Well, we're really looking forward to what will be a very robust discussion today. Thank you so much for being part of it. And with that, I'm very pleased to turn things back over to my co-chair, Brian Bird, who will be introducing this morning's distinguished speaker. Thank you, Brian.
Well, thank you so much, Derek. And just before I introduce our first speaker, I just want to echo and reiterate Derek's gratitude to the Peter A. Allard School of Law for all the support to make this day happen. It's just been incredible. And for the support, the generous, very generous support of the Social Sciences and Humanities Research Council of Canada in making this conference possible by virtue of their financial support. And so with that, we'll get started with our first speaker. We're really fortunate to have with us the Honorable Justice Peter Lowers of the Ontario Court of Appeal, who will be speaking to us about pluralism in a free and democratic society. Justice Peter Lowers was appointed to the Ontario Court of Appeal in 2012, having served on the Ontario Superior Court of Justice since July of 2008. Before being appointed, Justice Lowers was a partner at Miller Thomson, LLP. He practiced in civil litigation, constitutional law, human rights, and administrative law, including education, municipal, and labor law, and appeared at every level of court, including the Supreme Court of Canada. As a lawyer, Justice Lowers lectured in his areas of expertise to, among others, the Canadian Institute, Insight, Canadian Bar Association, Ontario Bar Association, the Centre for Cultural Renewal, McGill University, and the Saskatchewan Institute of Public Policy, and published widely. Since his judicial appointment in 2012, Justice Lowers has spoken at events sponsored by the Ontario Bar Association, the Advocate Society, the Ontario Trial Lawyers Association, the Canadian Defence Lawyers Commission, and the National Judicial Institute. Justice Lowers received a Bachelor of Laws from the University of Toronto in 1978 and a Master of Laws from Osgoode Hall Law School in 1983. And he was called to the Bar of Ontario in 1980. And we're very, very grateful for Justice Lowers being with us today to kick us off, really to set the table very nicely with a talk on pluralism in a free and democratic society. Please join me in welcoming Justice Lowers.
Well, thank you very much for that kind introduction, Brian. I really have to cut my bio down. It's a bit distracting. Thank you, Derek, and for inviting me to come and address you today on this subject of pluralism in a free and democratic society. My wish was to be there with you physically, but I'm afraid that's not possible this year. I'm going to speak on Section 1 of the Charter. My framing concept will be Isaiah Berlin's axiom. He argued that there is no single way of life that is superior for all individuals, and that many basic goods are incommensurable and cannot be rank ordered. I see his argument as self-evident and beyond reasonable dispute. Berlin's axiom has political and legal implications for how free and democratic societies, like Canada, address the existence of moral diversity. According to Section 1 of the Charter, Canada constitutes a free and democratic society. We think we know what that means, but do we? Any common law lawyer knows from experience that new circumstances can shed new and revelatory light on an unnoticed but now emergent problem. Most concepts are serviceable until they are squeezed hard. Then the cracks appear, the fissures. Soon we wonder if we really understood what we meant, or what our interlocutors meant all this time when, together, we used those familiar words. So it is with the expression free and democratic society. Hard cases can reveal the cracks and fissures in foundational but under-examined concepts. So, what is the problem I want to address with you this morning? Consider the unsatisfactory state in which Trinity Western University has left Section 2, Section 15, and Section 1 of the Charter. I say unsatisfactory because even those who like TWU's result have found themselves unable to defend the majority's chain of reasoning. The majority found it to be permissible for legislation in the pursuit of statutory objectives to limit the individual freedoms protected by the Charter. But this view, said the dissent, fundamentally misconceives the role of the state in a multicultural and democratic society. The dissent quoted American political scientist William Galston, who said, "In a liberal pluralist regime, a key end is the creation of social space within which individuals and groups can freely pursue their distinctive visions of what gives meaning and worth to human existence." So what we see in TWU is the dissent explicitly advancing a notion of pluralist accommodation against its opposite, state-imposed orthodoxy, which the majority adopted implicitly. There was no agonistic engagement on this core issue. The majority did not respond to the dissent's challenge. That silence should be disconcerting in light of Berlin's axiom. The two approaches in TWU do reflect a deeper societal divide. So let me turn then to the two contending approaches. I'm having trouble framing the two contending approaches in intuitive terms. They reflect what McGill political science professor Jacob Levy calls mindsets. Both share a commitment to individual freedom, but they conceive of the role of the state in facilitating such freedom quite differently. The historical roots of these two orientations go very deep. The convergent mindset, on the one hand, expects the state to take an active role in promoting liberal values. It favors the centralization of political power and deprecates intermediate institutions, including the family, because they can be venues for the oppression of individuals. It has a paradoxical authoritarian edge. Levy points to Jean-Jacques Rousseau and John Stuart Mill as sources. The pluralist mindset, on the other hand, in its support of individual liberty, deplores excessive centralization, favors the existence of intermediate institutions, and prefers subsidiarity as an organizing political principle, in part in order to establish countervailing powers to limit state power. So let's think about the convergent mindset and the pluralist mindset. What drives the convergent mindset? Mill worried about the censorious reach of civil society itself. His seminal work on liberty is often remembered as focused on limited government, but its focus was actually on protecting individuals from the intrusions of civil society. Mill understood this to be the tyranny of prevailing opinion and feeling that would impose its own ideas and practices as rules of conduct on those who dissent from them. In Mill's view, defining the limit and maintaining individual freedom against civil society's encroachments is as indispensable to a good condition of human affairs as protection against political despotism. The authoritarian bent can be found in Rousseau's chilling words: "It is to your benefit that you are to be forced to be free." The convergent mindset sees moral disagreement as a temporary way station in the evolution of society. The idea is that moral disagreement will inevitably disappear as individuals come increasingly to see the wisdom of a common set of values. We will, so goes the argument, achieve rational consensus over time as moral disagreement withers away. The convergent mindset originated in relatively homogeneous societies. It was nurtured in Christian cultures where conflicting judgments about the human good were understood to be symptoms of error or heresies. What drives the pluralist mindset on the other side? Born of experience under despotic kings and tyrants, the pluralist mindset is deeply suspicious of overreaching state power. Drawing on Alexis de Tocqueville, Charles Taylor holds that a liberal state is neither an end in itself nor the source of individual rights. It is not meant to be an immense tutelary power with ultimate authority over the lives of individuals or as people as members of groups. Taylor and Tocqueville and others in that line assert that a robustly free civil society is a necessary bulwark against the mild despotism of an overweening democratic government. Now, we are accustomed to seeing rights issues in individualistic terms, but implicit in the pluralists' vision of civil society are intermediate bodies, families, communities, groups, and institutions. They instantiate associational rights and are the locus of much that gives meaning and purpose to the lives of individuals. The pluralist mindset holds, following Berlin's axiom, that moral diversity and disagreement are natural features of human life and of the way in which communities are formed. They are permanent features of life in a free and democratic society and must be accommodated. The tension between these two visions, convergence and pluralist accommodation, seems to be permanent and unavoidable. A society could not exist if there were undue accommodation because, in Yeats's words, things fall apart, the center cannot hold. And absolute convergence is what Galston calls civic totalism. It is simply another form of totalitarianism. Finding the right balance is not a problem with a single permanent solution to be set by a perfect verbal formula. Because the dialectic is in constant motion between the poles of convergence and pluralist accommodation, no fixed point or equilibrium can be found. So what does Canadian constitutional history tell us about this? The Canadian tradition has been coexistence. Our history reflects pluralist accommodation much more solidly than convergence. Consider the federal nature of Canada and the various group rights protected by the Constitution and the Charter, such as protection for language rights, minority language education rights, the right to denominational schools, and the protection of Indigenous rights. There are also protected associational rights. Canadian society's commitment to pluralist accommodation finds confirmation in the text of Section 2 of the Charter and in other terms of the Constitution Act. So said Justice Dixon in Big M. A truly free society is one that can accommodate a wide range of beliefs, diversity of tastes and pursuits, customs, and codes of conduct. He returned to that theme in Oakes now as Chief Justice, adding respect for cultural and group identity and faith in social and political institutions, which enhance the participation of individuals and groups in society. Group rights and associational rights serve to counterbalance the individualistic orientation that is found in the cases. Recall Chief Justice Dixon's trenchant words in Hunter and Southam. The Charter is the continuing framework for the legitimate exercise of governmental power and for the unremitting protection of individual rights and liberties. Freedom, he said in Big M, embraces both the absence of coercion and constraint and the right to manifest beliefs and practices. No one is forced to act. No one is to be forced to act in a way contrary to his beliefs or his conscience, and anyone so compelled cannot be said to be truly free. A free society, he said, aims at equality with respect to the enjoyment of fundamental freedoms, which are founded in respect for the inherent dignity and the inviolable rights of the human person. This understanding, on the individualistic side, reflects a classic liberal vision of personal freedom and limited government. So these competing mindsets of convergence and pluralist accommodation give rise to an abiding political, now legal debate in our time. In Canada, these two ways of grappling with diversity, convergence, which seeks to constrain it, and pluralist accommodation, which seeks to permit it, contend for dominance. And I suggest that none of civil society, academe, the courts, administrative bodies, legislatures, or the media have really grasped the dilemma. In the constitutional analysis, where would pluralist accommodation fit? It fits, in my view, into the constitutional pantheon as an unwritten constitutional principle under the now canonical approach to interpretation of text, context, and purpose. In my paper, I work through this particular mnemonic, taking into account the Quebec secession reference, Oakes, and the City of Toronto case. But it comes down to this, as I said, pluralist accommodation finds its place as an unwritten constitutional principle available for deployment in interpreting the text of the Constitution, including the Charter, and as an ingredient in the Section 1 proportionality calculus, something quite complicated in and of itself. I agree with Fred Schauer, who argues that in proportionality decisions, courts must acknowledge not only the way in which rights at times compete with other rights, but also, and more importantly, the way in which rights are superior to, but neither trumping nor excluding of other non-rights-based interests and other considerations. The all-in analysis at the end has to include all of these things. So then that comes to the next question. I come to the next question is, can convergence and pluralist accommodation be reconciled? There is a real tension even among accommodation pluralists about where to draw the line. Any political community, even a liberal democracy, has the right, if not the obligation, to secure the conditions necessary for its own survival over time. Charles Taylor takes the strong position that liberalism can't and shouldn't claim complete cultural neutrality because it is also a fighting creed and has to draw the line. William Galston proposes an answer to this line-drawing conundrum. A liberal polity guided by a commitment to moral and political pluralism will be parsimonious in specifying binding public principles and cautious about employing such principles to intervene in the internal affairs of civil associations. In his view, the state must rather pursue a policy of maximum feasible accommodation, limited only by the core requirements of individual security and civic unity. It follows, says Galston, that both democratic majorities and courts must forbear from using coercive state power to impose their own views on others, and instead to commit to moral competition through recruitment and persuasion alone. Further, there should be active resistance within civil society and democratic government, including the judiciary, against the lurking paternalist temptation for the state to take over all aspects of life. In answering the question about where to draw the line, accommodation pluralists posit a thin version of rational consensus, which follows logically from the core principle that the political structure of the liberal state is meant to serve society, not to be served. This brings me back to Galston's assertion quoted by the dissent in TWU, which perhaps now might seem more understandable. In a liberal pluralist regime, he said, a key end is the creation of social space within which individuals and groups can freely pursue their distinctive visions of what gives meaning and worth to human existence. But the problems in creating and maintaining hospitable social space should not be understated. It is easy to prescribe the duty of reasonable accommodation in the abstract, but that duty exists in tension with certain basic norms and standards from which we cannot accept derogation. Hence, Galston's prescription, to repeat, a liberal polity guided by commitments to moral and political pluralism will be parsimonious in specifying binding public principles and cautious about employing such principles to intervene in the internal affairs of civil associations. A free and democratic society must rather pursue a policy of maximum feasible accommodation, limited only by the core requirements of individual security and civic unity. That's the stance that I want to explore in my paper. Can we begin to identify the core requirements that Galston refers to? At bottom, the debate is about what should be considered socially acceptable on the one hand, and on the other hand, what should be considered socially unacceptable and therefore the proper subject matter of legal limitation, if not elimination. The paradigm example would be racial discrimination, which is absolutely unacceptable. There is a real effort afoot to prohibit absolutely other forms of discrimination. Most acutely these days, those based on gender, sexual orientation, and on various forms of sexual conduct, regardless of the source of moral objection. Some would see these as hot button issues, but I would say that the list of core requirements is much more banal. Because it is banal, we tend to lose sight of it, focused as we are on the fights. Now, I explore this point in my paper by considering Alistair MacIntyre's lament in After Virtue, that the West has lost its moral consensus. Then I ask whether free thought and free expression should be at the core. The loss of moral consensus leaves the law, on MacIntyre's telling, in a problematic state, he says, because the crucial link between the virtues and law is now missing. Knowing how to apply the law is itself possible only for someone who possesses the virtue of justice, as I hope I do. To be just is to give each person what each deserves, but that depends on the now contested social presuppositions of the flourishing of the virtue of justice in the community, which he says is gone. I resist MacIntyre's conclusion, which simultaneously overstates the need for moral consensus in society and understates the level of consensus that actually exists. In our free and democratic society, the right to life and the right to liberty for individual persons are two core commitments. Section 7. Take the right to life as an example. No one really disputes the core of the right to life. The disputes, serious and gut-wrenching as they might be, are on the boundaries of the right. For those at the beginning of life, abortion, and for those at the end of life, euthanasia. Each, even the predicted slow creep, is still on the boundary of the right itself. And so it goes, I would argue, with the virtues, settled habits, dispositions, and practices, and the moral values whose current contestation MacIntyre laments. While much might be contested by philosophers, political theorists, theologians, and activists, much more is actually not contested by civil society. Those virtues, values, practices, and human goods are found in the law. Indeed, our life in our free and democratic society would not be possible without them. Consider some. Keep your promises. Contract law. Take care not to injure your neighbor. Tort law. Don't pollute your neighbor's property. Nuisance law. Take care of your family. Family law. You can own stuff. Property law, personal and real. Take responsibility for illegal acts. Criminal law. The state must treat you fairly. Administrative and constitutional law. Can we add some vision of the common good to guide the state in securing the conditions for human flourishing as agreed? How about the rights and freedoms set out in the text of the Constitution, including the Charter and the unwritten principles? Now, in each of these areas of law and others that I have not mentioned, there are undoubtedly fields of contestation. but these actually engage matters of detail that do not challenge the core virtues and the moral values pursued in that area of the law. That's my argument. I now turn to something more difficult. Is there an argument that robust freedom of thought and expression should be strongly at the core? The psychological literature suggests that we need both in order to reason effectively. If we really knew what was going on, what works, and the truth about reality, our actions would more likely be successful. But as individuals, we have limited cognitive resources. We lack sufficient intelligence, knowledge, information, experience, and memory. Our thinking is often low resolution because we have accepted much on faith. We have not tested many beliefs, some of them even cherished beliefs, because we either trusted the source or we found the belief to be sufficiently coherent to be accepted. Apart from our lack of cognitive resources, we also engage in motivated reasoning, wishful thinking, and we are afflicted by cognitive biases. The most pernicious is the confirmation bias, in which we see only what supports our position and not what counters it. And what is more, thinking is effortful, and we are inclined to save energy. We are lazy, to be blunt. These are epistemic deficiencies that we can only overcome with epistemic vigilance. Motivated reasoning can lead to dire epistemic consequences, and bad reasoning can get things badly wrong in the real world. The way to overcome these epistemic deficiencies is argument. The sense that disputation can lead to truth is an essential element of the adversarial system and of our understanding of the function of the rule of law. This is no accident. We understand and accept that argument scrutinizes reasoning and helps overcome epistemic deficiencies. This means that we impair or limit argument at our peril. If we artificially limit argument, public disputation in all of its forms and forums, we defeat one of its purposes, which is to underwrite our ability to think, to learn, and to act effectively to good ends in the real world. Of course, some people might well be offended, even traumatized by what is said aloud. How do we cope with these predictable outcomes of a pluralist accommodation of free expression? Which brings me to the next subject. Should anti-fragile tolerance be a civic virtue? I would not hesitate to identify anti-fragile tolerance as a core principle in a free and democratic society and polity. Because the likely result of liberal pluralist institutions and practices will be a highly diverse society, Galston points out, the virtue of tolerance will be a core attribute of liberal pluralist citizenship. Tolerance is not too modest a virtue. Some might think it is too much because it is a robust virtue. As Benjamin Berger asserts, tolerance, he says, takes its place as robust virtue at those points at which the tolerating group thinks the other is blasphemously, disastrously, obscenely wrong. We need to tolerate other people and their ways of life only in situations that make it really difficult to do so. Toleration, we may say, is required for the intolerable. That is its basic problem. Now, I want to drill down by turning to the excellent work of Oxford professor Teresa Bajan. She argues that as a regime, liberal democracy is distinguished by its dedication to twofold toleration. First, of diversity in its members' fundamental identities and commitments, especially in politics and religion. And second, of the disagreements those differences inspire. Indeed, the self-conception, second, of the disagreements those differences inspire. Indeed, the self-conception of liberal societies as tolerant hinges on the fact that members are not compelled to confine their differences to the private sphere of individual skulls or intimate familiars, but are permitted, even encouraged, to demonstrate, to express them freely in public and to compete for adherence. Now, the 17th century evangelical firebrand Roger Williams is the hero of Bajan's story. He was the founder of Rhode Island. Bajan calls him an intolerant tolerationist, noting that in addition to being personally obnoxious, he was a religious fanatic of exemplary intolerance, constantly alert to what he saw as others' irredeemable errors. Bajan explains Williams's thinking. For Williams, mere civility made toleration possible by allowing individuals to permit while nevertheless protesting against that which they could not approve. Here we come to the crux of its importance for Williams as a conversational virtue, compatible with the antagonistic evangelism he practiced and preached. The reason is, she explains, all must be tolerated because all were potential converts. She cites this passage from Williams. He that is a briar, that is a Jew, a Turk, a pagan, and an anti-Christian, a Catholic like me, for example, today he may be, when the word of the Lord runs freely, a member of Jesus Christ tomorrow. In short, Williams was tolerant so that he could be evangelical. Now, Williams was the first to use the wall of separation metaphor to describe the necessary separation between the church and the state. In his view, no one should be excluded from the public sphere of life on account of any religious convictions or lack of convictions. Bajan describes his view of the public square. The magistrate's role was not to stifle any disagreement that might upset the peace by imposing another form of civil silence, but rather to secure the conditions under which those disagreements, along with the annoyance, disapproval, and disgust they inevitably gendered, could proceed. This is, in fact, the paradigmatic free public square. Bajan concludes, a low standard, loosely applied, combined with thick-skinned determination to tolerate what we perceive as others' incivility, these were the essentials of Williams's mere civility. She adds that the standard of mere civility is demanding, but in a different way. It calls upon individuals to display the mental toughness necessary to manage and mind the gap between what we would have others think of us and in general, and of what they actually do. In this, it shifts much of the burden of civil conversation from the speaker to the listener, requiring the latter to cultivate, among other things, insensitivity to opinions and an identity separate from that immersed in debate. Makes you think of Twitter, doesn't it? Life in a free and democratic society does require a measure of personal toughness. As Justice Gonthier said in Chamberlain, the key is that people will disagree about important issues, and such disagreement, where it does not imperil community living, must be capable of being accommodated at the core of a modern pluralism. It is a feeble notion of pluralism, he added, that transforms tolerance into mandated approval or acceptance. These strong words, judicial words, should give force to Galston's argument that social space must be protected within which individuals and groups can freely pursue their distinctive visions of what gives meaning and worth to human existence. In a free and democratic society, can we reasonably demand more than tolerance from our fellow citizens? Perhaps the virtue of anti-fragile tolerance has the vitality to guide judicial thinking in the clinch of hard cases. This would reinforce pluralist accommodation as an essential element of our free and democratic society within the meaning of Section 1 of the Charter. So I'm wrapping up now. I covered 6 questions this morning to pull them back into focus. First, what does Section 1 of the Charter mean by the expression free and democratic society? More specifically, what does it include and exclude? What are the two contending approaches? What does Canadian constitutional history tell us about the right road? Can convergence and pluralist accommodation be reconciled? Can we begin to identify the core requirements of civic unity? And should anti-fragile tolerance be a civic virtue? Not a single one of these questions is small, but we should not easily dismiss them. Thank you.
Thank you so much, Flowers, for that very enriching talk. And many of those questions that you have summarized at the end are going to be with us. Maybe all of them will be with us for the rest of the day, I believe. So you've really helped us get the spacecraft off the launch pad. I think we've achieved liftoff. So thank you so much for that, Justice Flowers. Really appreciate you helping us get the day started. And we're going to keep it going. We're going to have our first full panel of the day basically right away. So I'll invite our panelists for our first panel on limiting freedom and equality to make their way to the table down next to me. This panel will be talking about the relationship between Section 1 and certain fundamental freedoms, as well as Section 1 and equality in Section 15. So as our panelists make their way to the table, I will apologize for shortening their bios. I was looking at, I have the bio document here, which they're all very impressive, and they're all online. If you want to take a look at our panelists, their bios, if you just go to christianlegalfellowship.org/Section 1 Symposium, you'll find, among other things, the document that includes the biographies of all of our speakers. But I will keep our introductions brief, and I hope that they're okay with that. If nothing else, to maximize our time here together so they can speak for a bit more, so you can hear from them. So I'll start off by welcoming Professor Jamie Cameron. Professor Jamie Cameron is Professor Emerita, Allard Hall Law School. We're very grateful for her being with us today. We also have Professor Hoy Coleman, Allard School of Law. He is the inaugural holder of the Right Honorable Beverly McLaughlin UBC Professorship in Constitutional Law. We also have Professor Dwight Newman, QC, of the University of Saskatchewan College of Law, and holds Canada Research Chair in Indigenous Rights, Constitutional and International Law. And finally, our discussant who will be helping us weave things together is Professor Blair Major of Thompson Rivers University. So really, we're just keeping the space shuttle moving here. This is wonderful. We have a wonderful panel for you. Again, on limiting freedom and equality. Please join me in welcoming our panelists. I think we'll start off with Jamie.
Okay.
The floor is yours. Feel free to come up to the lectern. You can use the mic, whatever you prefer. Panelists, you have freedom to speak. You're at the table.
Thank you very much, Ryan. It's a great pleasure for me to be here at UBC, to be present at this symposium, and to be on this panel with my co-panelists and our discussant. I just want to begin by expressing my appreciation to Brian and Derek for including me in the symposium, and including me in the annual symposium. And at last year's symposium, I started a project to overhaul Section 2B's doctrinal edifice, and Hoy was actually the discussant on my paper. So the idea there was that after so many years of complaining about Section 2B, perhaps I ought to finish up on a more constructive note. And so I began on a do-over of Section 2B methodology that works both sides of the equation, both the concept of breach and the analysis of justification. And the reason for that is my view that the Section 2B methodology is way out of balance, way out of whack. And I'll just give one example. It's a favorite of mine. If we take a look at the Supreme Court's very important decision in Saskatchewan Human Rights Commission versus Whatcott, perhaps others have not noticed, but I did, that an analysis of Section 2B is a one-paragraph long. The analysis of Section 1 and justification by comparison is 88 paragraphs long. So that's just an example. There could be others. That one's perhaps a bit more dramatic, but in any case, my view was that you can't really fix Section 1 without also looking at Section 2B and its concept of breach, and that once you address Section 2B, what you realize is that the Section 1 analysis cannot remain the same. So my goal has been to work on a kind of a holistic or integral approach to Section 2B and to the Charter's concept of expressive freedom. So I will be conscious of time, and there are a lot of moving parts in my proposal. But I'll just begin for a moment with the key takeaways under Section 2B. This was last year's project in the main, and they are two in number. The first is that, try as you might, you will find little or nothing about the concept of freedom itself in the Section 2B analysis. And what I maintain is that there is a difference between protecting freedom and protecting expression. So that's a little bit abstract, and I don't really have time this morning to explain it further. But what I will say is that in thinking about a constitutional protection for freedom and the concept of freedom, I returned to the 4 great pre-charter decisions that do discuss freedom in a meaningful way. And these are the Alberta Press reference, the decision in R versus Boucher, I guess it's Boucher versus the King, the Sommer case, and then Switzman versus Elbling. So that's point number 1. What Section 2B is missing, first and foremost, is a concept of freedom. Second, the analysis of breach in most of the Section 2B jurisprudence is pretty much empty. And what then proceeds to Section 1 is a bare finding of infringement. And Watcott sort of demonstrates the point, but there's little or no discussion of the nature of the interference with freedom. And so I address that in a doctrinal way. And as I said, it's a bit more complicated than I can get into this morning. But what I did was to address this issue by reworking the Irwin-Toy framework. I did leave step 1 in, the attempt to convey a meaning test, because I can't abandon everything. But what I did argue strenuously for is the elimination of the purpose effects test. And I proposed replacing it with the Section 2B standard of infringement from Amselem. And that's the standard of breach that asks whether the interference is beyond the trivial or insubstantial. The further point is that in addressing whether the interference is more than trivial or insubstantial, that is the place where the nature and severity of the interference with freedom can be engaged and worked up under Section 2B. So what I proposed is that there be that workup under Section 2B, which is missing now, and that it can take place under an alternative conception of breach that eliminates the purpose effects test for reasons I could explain at great length, and replaces it with the Amselem standard, which has the added value of bringing Section 2A and 2B into better alignment on the breach part of the analysis. So the result is a proper workup under Section 2B and a more robust conception of the interference that goes forward then to Section 1. It's not like an empty or bare finding of breach that arrives in Section 1, but an understanding of what the significance of the interference is. Gosh, that took a little longer than probably it should have. But moving on, we're now ready for Section 1 and what I say about Section 1. So we all know that the weight in most Section 2B cases is on Section 1. And there I maintain, and this is not particularly new, I suppose, but I maintain that there's 3 key problems. The first is the contextual approach. And it's long been my view that the contextual approach attenuates the standard of justification by finding that low value expression, which is almost every expression they look at under Section 1, doesn't really deserve protection under Section 1. And I guess it just seems self-evident to me that the Charter cannot plausibly protect expressive freedom under a system for determining reasonable limits that is based on overt judicial perceptions about the relative value or lack of value of expressive content. And I'll be a little bit irreverent here and say that in my opinion, that is simply and galactically wrong in principle. So my proposal completely and entirely eliminates the contextual approach once and for all. And I actually do have an alternative that I'm coming to in a couple of minutes, but have to get my other 2 problems about Section 1 analysis on the table. So the second one is that the Section 1 analysis in what I'll refer to as content-based cases is not evidence-based. Decisions under Section 1 are not based on evidence. In lieu of evidence, the court tends to rely on common sense, relies on experience, and there's a lot of deference that goes on, even and perhaps especially in cases concerning political expression, which is supposed to be the core Section 2B value. The most evidence-based cases in the Section 2B jurisprudence are the open court decisions. Those remain the ones that I always praise as being the model of decision-making on justification. So my third point, and it's closely related, has to do with the conflation of the concepts of value and harm. So in the absence of evidence about harm, what tends to happen is that the low value step in the contextual analysis steps in, and the assumption is at least implicit that expression that is low in value, almost by definition, is also harmful enough to be limited. And so those are the three problems that I think are most significant in the Section 1 analysis and Section 2B cases. And on the last 2 points about evidence and harm, I guess I do have to take the recent Supreme Court decision in Ward versus Quebec out of the mix. And I also want to very quickly acknowledge some counterexamples. One of them, and I know he's not here, but one of them is former Justice Binney's dissenting opinion in the City of Montreal noise. Oh, there you are. You are right there. So here we go. It works. The dissenting opinion in City of Montreal and the anti-noise bylaw. So I'm sorry to say this, but this dissenting opinion is generally overlooked, but in my view, it is an absolute model of principled Section 1 analysis. So in fact, I'm right now doing a series of 5 blogs on Section 2B, if they ever get done. And in the one I'm working on now, I've got 2 lists. I've got my 2 top 10 lists of Section 2B decisions, best and worst. And City of Montreal is on the good list, just so you know. Anyway, I finally, I'm coming to my alternative to the contextual approach. I accept the general idea of the contextual approach, which is that the engagement of competing interests has to happen. I just don't like the way it was done under the contextual approach. And I think it's interesting that when the contextual approach was introduced, first as a trial balloon in Edmonton Journal, and then doctrinally in Chief Justice Dixon's opinion in R versus Keegstra, it's interesting that when the contextual approach became doctrinal under Section 1, proportionality balancing was kind of a throwaway. And if you need authority for that, just check the late Peter Hogg's textbook on constitutional law. Anyway, eliminating the contextual approach under my proposal creates an opportunity to reposition proportionality balancing and to give it a new prominence. It's had increasing prominence in recent years, but I would give it significant prominence in the revised Section 2B methodology. And I think it's key to remember why we do proportionality balancing. It's because the violation has already passed the other parts of the Oakes test. And so at this final stage, it is all about the deleterious consequences and whether they are justifiable at the end of the day. So I would say that under proportionality balancing, the focus is on the deleterious consequences. And here is where my revised concept of breach comes into action, because we've got that workup from Section 2B as to the nature and severity of the infringement. And now we can drop it into Section 1, into that deleterious consequences function of proportionality balancing. And in that location or venue or role, it can inform the Section 1 analysis. And then once the deleterious consequences are brought in from Section 2B into Section 1 and fairly identified, the onus is on the state to show why the salutary benefits outweigh those consequences. And I would just say, I'm almost finished, but I would just say, I want to recall the words or the words at the opening this morning, in which Derek paused to, I want to pause to endorse and echo Derek's opening remarks about Section 1's role in guaranteeing rights and freedoms, and to say that that function must be more explicitly recognized in the case of Section 2B. And so that was a good suggestion for me. So my idea of proportionality balancing can't just be open-ended, and it actually requires structure. Haven't figured that part out yet, but I am working on it. And I know that I can't overcomplicate the Oaks framework to make it even more of a nightmare, but I do think that it can't just be open-ended balancing. So I'm going to go back to my top 10 cases and maybe some of the others and see if I can find ways to show what this might look like going forward. So the bottom line is that for Section 2B to stand a chance and for expressive freedom to stand a chance under the Charter, the violation must be taken seriously under Section 2B and Section 1. The analysis of breach must identify the insult to freedom at the first stage of the analysis, and under Section 1, the contextual approach must be eliminated. The requirement of evidence-based decision-making must be respected, and proportionality balancing must play a speech protective role.
Switch gears from freedom of expression in Section 1 to equality in Section 15 and Section.
I can stay here, right? Sure. Oh, great, thanks. Thank you so much to the organizers for the petition and for bringing us all together. It's such a privilege to be able to spend time with my co-panelists and with you all. So here's the puzzle under Section 15. There's been a sort of ongoing debate for decades about the appropriate relationship between Section 15, the equality rights provision, and Section 1, the justification provision. And one of the core questions is, well, what is the role of means-ends reasoning within Section 15? What I mean by this is, so we know under Section 1 that we have to figure out whether there is a legitimate governmental objective and a rational connection. Yeah? And over the decades, scholars and courts again and again say, well, we should not import Section 1 considerations into Section 15. So over the decades, there have been different resolutions of this problem. So in 2020 case of Fraser, Supreme Court of Canada, in its majority reasons, says, I want to present this as a hypothesis, evacuates the means-ends reasoning from the Section 15 analysis. And it does so in a passage in which the court says, it is not the place in Section 15 for the claimant to show that state action is arbitrary under Section 15. It is the role of the government under Section 1 to show that it is not arbitrary. That's the claim. So that's the current state of the law. And so let me pose three challenges to this vision of Section 15 and the relationship between Section 15 and Section 1 around this question of means-ends relationships. I want to advance in doctrinal arguments, a conceptual argument, and an interpretive argument. So let's begin with the doctrinal argument. So the doctrinal argument is relatively simple. Justice Abella, writing for the majority in Fraser, makes this claim that arbitrariness is not to be considered under Section 15. It is the role of government to show that state action is not arbitrary, which is interesting because in Quebec a few years earlier, Justice Abella, writing for the majority, says that arbitrariness is a part of the Section 15 analysis. So in Fraser, in the 2020 reasons, there is an implicit overruling without an explicit engagement with the precedent, right? Without an explicit explanation of why arbitrariness, this component of the Section 15 reasons for decades, is no longer a part of the analytic framework. That's the doctrinal reason. If you're going to overrule expressly with reasons, not by assertion. Second, there's a conceptual problem. So the problem the way the Section 15 problem is often posed is, look, we can't possibly consider legitimate objectives and this relationship between means and ends because we would be simply duplicating section 1. Yeah, we'd be placing a burden on the claimant that is properly of the analysis that is properly placed on the government under section 1. Well, let me just raise a kind of conceptual distinction. So the way that the doctrine has figured out this relationship within section 15 is to say, look, what we're worried about under section 15 is the correspondence between the claimant's conditions, right, and the law, right? So the focus under section 15 is on the claimant. Yeah. Now, this is, by the way, consistent with other parts of the charter jurisprudence. So if we think about section 7, gross disproportionality under the principles of fundamental justice under section 7, right, is a means-end relationship focused on the claimant under section 7. And then the court says when we do proportionality with effects under section 1, it's a broader analysis, right? It's analysis of general legislative objectives, the sort of general balancing, not necessarily focused on the claimant, right? So it is possible conceptually to distinguish between the means-end reasoning happening under section 15 and that which happens under section 1. It is conceptually possible, and it is doctrinally possible because it is consistent with how the Supreme Court of Canada handles this question in other parts of the charter. So that's a doctrinal challenge, a conceptual challenge, which merges with the kind of doctrinal challenge, which is to say that this relationship between means and ends is consistent across other parts of the charter and is not sort of, as it is sometimes presented, as if it's some sort of anomaly. Let me close my presentation with what I think of as kind of an interpretive challenge to this rejection of considerations of arbitrariness under section 15. So the Supreme Court of Canada in Fraser says that in order to show that there is a distinction drawn on an enumerated analogous ground, right, the claimant has to show that, has to point to evidence about the situation of the claimant group and the evidence about the effects of the law on the claimant group. But not both. It's whether or not you need one or the other is contextually dependent, right? And in order to show that there's discrimination, you need only show that the law reinforces, perpetuates, or exacerbates a disadvantage. Yeah. So in that statement of discrimination, Justice Isabella from the majority eliminates this question of arbitrariness, which the dissent, repeating the line of the cases from Quebec and A, articulates. They say, look, arbitrariness is a part of this analysis. So here's, and the dissent in several section 15 cases raises this problem, right? It is at least possible that if you follow this reasoning in Fraser, the simple existence of a difference in circumstance and a disadvantage between a group in Canadian society who has already suffered from pre-existing disadvantage, right? We can simply show that that disadvantage exists under the law that's being challenged. Not that there is some sort of unfair treatment, but that disadvantage persists under a law, right? So what is the interpretive implication of this? I suggest that what it does is it potentially places governments under a obligation, a section 15.2 type obligation to ameliorate the conditions of disadvantaged groups, right? Now, section 15.2 is understood generally as an empowerment provision, right? Governments are empowered to advance the conditions of disadvantaged groups. The risk I suggest under the Fraser formulation is that this empowering provision becomes converted into a constitutional obligation, right? The simple fact of disparity is sufficient to place an obligation on the part of government to rectify disparity, right? And that I suggest is to collapse section 15.1 and 15.2 and to offer a novel interpretation of 15.2, which I think is unwarranted by the text. So I started with a puzzle about the relationship between section 15.1 and section 15 and section 1, right? This puzzle about the relationship between means and ends, which has plagued the jurisprudence for decades. I laid out the resolution of that debate in the Fraser case, and I've suggested 3 problems with that resolution. They're jurisprudential, conceptual, and interpretive. And with that, I'll pass the floor on to my colleague, Dwight Newman.
Well, good morning, and thank you for having me here as part of the conference. It's wonderful to be here at the Allard School of Law and to engage with all of those that are here at the conference and on the panel and beyond. I'm going to talk this morning about several proposed changes to the Section 1 analysis. And I'm going to do that in response to what I'll suggest are some potential weaknesses in the proportionality analysis as an approach to Section 1. I'm not going to frame that in radical terms that call for overturning Oakes, but I'm going to frame it in terms of several implications one could draw out of Oakes in some respects that also make Oakes as an approach ultimately more meaningful, but may set the stage for a different approach down the road. Canada's use of proportionality analysis in the Section 1 Oakes test didn't specifically follow the text of Section 1. It wasn't compelled by the text of Section 1, but it followed an internationally used approach to rights limits, and a very popular one. The proportionality-based approach is used in states around the world. Not in the United States so much, but in many other states, this is the approach. And the Supreme Court of Canada in the era of Oakes was enthusiastic about this kind of proportionality-based approach, so much so that in its early comments on the appropriate approach to limitation of Section 35 Indigenous rights, with a very different constitutional text in Section 35, the court adopted an approach that had a lot of similarities to Oakes. And in fact, they've come even closer together in more recent jurisprudence, in some respects in the Chilcotin test or Silcotin test for limits on Indigenous rights. There are additional requirements that apply, but the proportionality component of the test is all the more similar as between the Oakes test and the Sparrow test as modified down the road. There are more detailed doctrinal things we can say, but looking at the schematics of the proportionality approach and some of its consequences is where I want to point to some potential challenges with it. So one difficulty with the Oakes test is that it doesn't necessarily provide an approach to rights that's consistent with some rights theory and a protection for rights of a sort that some would urge for what's appropriate for rights. And there's much more we could say about that. One of the things I've had to do in engaging with this topic is to wrestle with the fact that one of the first publications I ever did was on Oakes and Sparrow. And so in 1999, I published an article where I said some critical things about the Oakes test. In wrestling with this childhood article, there are things about I still agree with, but there are things I definitely disagree with. But the things I agree with are in part that at one level, the Oakes test doesn't give all that much protection in some deontological sense of rights. In many respects, it's mathematically equivalent to different kinds of cost-benefit analyses. If one were to press it to its cynical limits in some sense. So look at the schema of Oakes. It requires a sufficiently important objective, a rational connection, minimal impairment, and overall proportionality balancing. The phrasing of each of those components has changed over time. There are significant differences in legal language over time in terms of how deferential or not each of those two pieces is. And that's legally significant, but at some level, what does it do? Government legislation should pass the first two steps unless government has been very irresponsible. So if there's not a sufficiently important objective and or if they've been utterly irrational, something's gone very wrong in terms of the reason why they might be limiting a right. And there are cases where government restrictions on rights have been struck down on those bases, but it says something pretty negative about the government legislation in question if that's where it fails. Most of the work, of course, is done at the minimal impairment stage, although how deferential that is has changed over time and has become somewhat more deferential. And then there's this last stage, the overall proportionality balancing that has, as Jamie has referenced, sometimes hasn't seemed all that meaningful. Peter Hogg came close to saying it should just be dropped from the analysis. And then the court came back and said, well, it has a role to play. But these pieces ask, could the government do the same thing in a way that wouldn't make anyone worse off? Would be one way of thinking about the minimal impairment branch. And that's essentially what in economics would be called a Pareto efficiency requirement of asking whether you can do the same thing without making anyone else worse off. And then the fourth stage is a standard cost balancing criterion that asks, well, on the overall benefits and costs, is this an acceptable policy? I don't want to overstate this, and in my childhood article, I probably overstated this. But there is a sense in which the Oakes test is a very consequentialist test, an almost utilitarian test for rights limitation, and one could offer a more general critique of it on that basis. But more significantly, thinking in practical terms about what this means, there's the possibility of strategic legislative design that relatively easily meets the Oakes test. And one example I would point to that's somewhat stunning in this regard is the Hatarian Brethren case. If the government's objective in the case, so this is the case concerning the driver's licenses in Alberta and the requirement of having a photograph on a driver's license, to which a very small number, a couple of hundred people in certain specific Hutterite communities had a religious objection. If the government objective is framed as maintaining security in some general way, they would struggle to meet the Oakes test on that basis. But if the government objective is to have a complete database of photographs on driver's licenses, they meet the Oakes test very readily. And it's really just the way the government policy objective is stated in some respects, or the strategic design of the legislation that enables a meeting of the Oakes test. So how much protection does it offer? There are more complex things one could say about any given thing I'm going to say this morning. But at some level, there are at least bases for wondering about the protection that it offers. So that's one concern, is how much protection does the Oakes test offer? A second and paradoxical kind of element, well, there are other paradoxical elements, but a second element, I'll just say, is that because it requires so much information for its application, the Oakes test has the potential to slow down litigation or even make it impossible in practical terms to litigate certain rights claims. So the idea of the Oakes test and the way in which it's applied is obviously to place the burden on governments to justify limits on rights and freedoms. But the degree or the way in which it does that has the potential to prolong litigation that can actually impose significant burdens on rights claimants. And some rights claimants won't have a problem with this. And in fact, that's actually led to shifts in the way in which the Oakes test was applied. If one goes to the mid-1990s tobacco cases, tobacco companies could litigate very effectively on a rich evidentiary record. And then you have a shift to thinking in terms of the Oakes test in terms of a more common sense application as it's put in some of the case law. Well, for others though, the Oakes test makes it very challenging to litigate upon limits on rights or freedoms, or as I say, may make it almost impossible in some situations, notably in an emergency type situation or an urgent situation, because the Oakes analysis has a complexity to it. It needs a large evidentiary record to be put before the courts. And as a result, it's not possible to have a rapid determination of a matter where the Oakes test is pertinent. So where's an example of this? When the government developed various COVID policies on an ever-changing basis over the last 2 years, it wasn't easy for anybody to put challenges on some of those. If the government 3 days before Easter says that they're going to impose some extra limits and require that church services shut down for Easter, but it's okay to keep the liquor stores open and the cannabis stores open, and maybe to have a concert too, that should be something that should be possible to challenge. I'll come back to that specific example, which is a bit stylized and exaggerated slightly, but I guess it becomes impossible to litigate upon that in the 3 days ahead of Easter, because the evidentiary record that's going to be put to justify the infringement will be some thousands of pages, or at least hundreds of pages, some affidavits, various different things. It doesn't permit an effective review of the government restriction. So is there a way to face up to these? Some would say, and there are arguments out there, for some type of whole-scale replacement of the Oakes test, although it's not always said what exactly that would look like. And I'm not sure that that's a very realistic scenario even to aim for. The Oakes test is one of the most entrenched legal tests in Canadian jurisprudence, cited hundreds, even thousands of times, maybe even tens of thousands for all I know. But there are maybe more nuanced ways of addressing these weaknesses. And I'm arguing this paper for adopting what I call Section 1, some of what I call Section 1 maxims, or we could put it less technically and call them rules of thumb. And I'll also argue for a new Section 1 best practice in certain contexts. And my time is going fast, so I'll have to zoom through these. In terms of Section 1 maxims or rules of thumb, I think that some of these would derive from the Oakes test, but allow for a lessening of unnecessary burdens on rights claimants. One of those, of course, and almost recognized already, would be that limits on rights or freedoms that verge towards a purpose of limiting the right or freedom in question will fail the Oakes test without requiring further analysis. And we have case law that comes pretty close to saying exactly that. There have probably been examples where that comes close to being pertinent. One could talk about some of the more extreme versions of the summer jobs program attestation, and it went through different iterations. But in a more extreme version, it comes very close to saying that organizations can't hold certain views or can't adopt certain positions. And in some of those, you might come close to that, but set that aside, because that's not going to be a controversial rule of thumb or maxim. It will be controversial in the application, even in the example that I state. So there would be argument on that. But let's consider a second possible rule of thumb, which would be that a policy that treats rights or freedoms worse than non-rights interests that are closely analogous will fail the Oakes test without requiring further analysis. And you get an example. This may not be the exact way to phrase it. I'm doing this simply. But for example, treating religious facilities or places of worship worse than secular facilities in the context of COVID restrictions, where they're closely analogous, there's probably an automatic failure of the Oakes test on religious freedom grounds there, and there are American cases that recognize that, but it wasn't possible to say that in the same way in the Canadian jurisprudence, even though I'll say this rule is logically entailed by the minimal impairment branch and by the very nature of rights themselves. If it would have been possible to achieve the same benefits to public health by applying a balanced approach to different institutions at the same time, but all the burdens placed on religious institutions, there's inherently more restriction on religious freedom than there would need to be to achieve the same objective. You could get a more rights respecting approach in that scenario. So I'll turn to the last piece and just say that I'm not urging this actually as an absolute requirement, but as a best practice that governments should consider adopting, although maybe over time it develops in some different way. I think there's something to be learned from the Sparrow test for the Oakes test, given the analogies between them. This thought arises naturally. The early jurisprudence on Section 35 treated elements like the payment of compensation and whether there had been pre-infringement consultation as sort of extras that might assist in an infringement analysis, but not as absolute requirements. And then there was the development of a proactive duty to consult doctrine, where governments have a duty to consult potentially affected Indigenous communities when government action might adversely affect an Aboriginal or treaty right subject to Section 35 protection. Some extra requirements there in terms of governments having actual or constructive knowledge of the right, them making a decision that has the potential for that adverse effect, and there being that rights claim an issue. I've written lots on this duty to consult doctrine. It arises obviously from the honor of the Crown, which has a special role in that context. But I'll suggest that one thing it does is it also provides information to governments. And so one scenario I sometimes talk about with my students on is it removes the possibility, which would be dishonorable for the Crown, of the Crown simply going ahead with a decision and dealing with an issue about rights infringement later on down the road. Well, that would be a dishonorable government approach if they knew they were doing that. But what's going to arise more often is that governments don't know that they're actually having a more significant effect on Indigenous communities than they realize. And consultation is a mechanism that makes them more aware of the degree of severity of their impact than they were before. Well, the same might apply in the context of certain kinds of limits on charter rights. And I suggest in the paper, and I need to wrap up, but basically there are some situations that may be more analogous to this than one first realizes. In the context of religious freedom, for example, governments may not understand well, in the context of increasingly secular governments, may not understand well what it is that's at stake for religious communities. So where there are particular gulfs in understanding between governments and those who hold certain rights and freedoms, there may be a way in which consultation highlights ways of achieving a government objective while having a less rights impairing effect. I draw an analogy also in the context of collective rights and religious communities alongside Indigenous communities. There are complexities that arise from the collective context. I'm just going to skip over that. I'll just say I did a little bit of looking at comparative COVID policies that affected religion in different provinces and US states. Jurisdictions that engaged and consulted with faith leaders when they could in advance of developing government legislation. I don't suggest they could have done this before March 14th, 2020, but maybe they could have by October 2020, and some jurisdictions did. Well, those that did were able, in some instances, to devise policies that were effective while having fewer negative impacts on religious freedom. It actually enables an achievement of the minimal impairment stage to carry out consultation to find good information. I don't argue for making that an absolute requirement in the context of charter rights. There are practical considerations that come to bear. The duty to consult on Section 35 is triggered hundreds of thousands of times a year in Canada already. And the charter context, we'd want to be careful about adding that layer of complexity, but it may well be a good Section 1 best practice for governments to consider adopting in the kinds of circumstances that make it pertinent. I'll stop there and just say the effort in this paper is to try to offer some ways consistent with Oakes of moving towards approaches that don't depend upon applying the full Oakes framework. Down the road, maybe that leads to a different framework, or maybe it just leads to some better ways of applying Oakes in a period in which one can identify some challenges with it. So I'll stop there and look forward to critique and challenge to try to help me improve some of this.
So can you hear me? Yeah, I think this is on. So now I have the not enviable challenge of trying to respond to some incredible ideas that have been put forward in what was it, 7 minutes, Brian? Oh, thanks a lot. Thanks a lot. So I have pages and pages of notes, and so I won't be able to speak about them all. Obviously, we'll have lunch together, right? And so we'll talk about it more then. First off, just appreciate the work that all of you have done, and knowing that I won't be able to get into the details of how I'd like to reflect on all of your papers individually, there was just a couple of thoughts I thought that came up for me when I was looking at your papers as a whole. I mean, there's obvious points of overlap, especially between Dwight's and Jamie's papers, struggling about what's the role of context and principle when we're looking at the application of the Oakes test in justifying limitations to rights. And they're trying to wrestle with it in different ways. So for example, this idea of maxims being brought up by, or rules of thumb being brought up by Dwight is one way to try and manage that tension between the two of them. And then Jamie speaking about moving away from presuming kinds of harms or making assumptions, judicial inferences about what is harmful and moving toward an evidentiary basis for it, I think are both speaking to a very similar type of issue. And so one of the big questions that stood out to me when I was listening to these presentations and reading what they had provided to me in advance was how Section 1 in the Charter spells a general analysis for infringements of all of the rights that are protected in the Charter. But as we see in the presentations, it seems to be applied in different ways depending on the particular right that's being infringed. Now, I know that there is a little bit of sort of judicial consideration about this, not in a lot of depth, and I wonder whether or not, when we're in the question and answer, if you would be able to speak to whether or not you see the paper you've approached as suggesting that Section 1 should either be uniform across its application to different rights infringements, or whether it should be calibrated. We should be more express about calibrating it to be distinct when it's being applied to different types of rights infringements. And I think that could be really, really helpful for establishing some cross-pollination between your ideas, as well as thinking across different types of cases. Now, I can probably anticipate some of the responses to that question, but I think I'll just leave it open-ended like that. And I'll just, for just a couple minutes that I have here, I'd also like to turn to each of the papers individually and just a couple of high points that I thought jumped out that I'd like to comment on. So I'll kind of go down the row. If I don't get to you, Hoy, it's Brian's fault.
I always blame Brian for everything.
So first, Jamie, I really appreciated your efforts, especially drawing attention to the pre-charter cases. I love Justice Rand's discussion of what freedom means in the 1950s decisions, especially of Somer. I think it's just a wonderful decision. So I know that was last year's paper, but it's still very, very relevant for what you're doing now. And I just wanted to say that I think it's connected to this when you talk about how discussing what's actually being infringed when there's a interference with expression, that getting short shrift and then ending up sort of as a bare, almost nothing going into Section 1. And then how do you weigh that on the scales when you're balancing? Is something that I see present in my own work around religious freedom as well, and the Section 1A balancing. So this idea, and I've talked about it before in my own work, is sort of like stacking the deck. Section 1 in some ways is kind of stacking the deck in favor of the government. And so it sort of raises, I think it's an excellent point, and it's worth spending time reflecting on. I wonder though if proportionality maybe holds some false promise, because in my experience looking at Section 2A violations that go to Section 1, and that was the example for you where you get more discussion of the nature of the infringement and how like the severe deleterious consequences of the infringement, they still seem to be faced against a deck stacked against them. And so I wonder whether proportionality may actually because of what you've observed, may actually continue to be a bit of a problem. So that may be something to consider and to turn your mind toward. And then the second question I had for your second point was around your desire to move away from or move toward having more evidence of harm being needed to justify limitations in the Section 1 analysis. And so I'm curious I can imagine some of the things that you hope that will get rid of, right? Or things that you think it will get rid of. But I wonder if there may be sort of other consequences of doing that. I'm thinking specifically of some of the work of people like Jeremy Waldron or Joseph Raz, who speak about broader issues of social recognition or disrespect that are present in being protected in through Section 2B that we might sort of lose track of. Because how do you demonstrate those types of broader social harms? Now, maybe that is something that you would like to see diminished, but I think it would be worth at least commenting on the pretty clear effect that will have on removing that or diminishing its role in the Section 1 analysis. Then for Dwight, we spoke a little bit earlier today. I find your paper absolutely fascinating and wonderfully creative in drawing together sections 35 and this idea of consultation, a duty to consult, and Section 1 balancing. What I wanted to do though in my comments is that, so I think it's really fascinating, and I think I just need to rewind for just a moment, is that I found that your paper, I just want to comment, I think your paper, and I said this to you this morning, your paper in 1999, your childhood paper, as you called it, was where you compared Oakes and the Sparrow test, was actually really interesting. And I think it was really helpful for me to clarify what you're aiming to do in your current paper now. So there are a couple quotes from that 1999. So this is sort of like, imagine sort of an infant Dwight, much shorter, saying these things. So he says in there, all our theories of rights limitations are ultimately based on structural readings of the Constitution, which I think is a fabulous observation to keep in mind. And also, you call in that paper for renewed attention to how limitations on rights interact with the government's responsibility to the people to preserve their dignity, freedom, and democracy. And I think that you offer these ideas, these sort of big ideas, as a way to help navigate the tensions within Section 1 that I mentioned before, with both the principles and the context that are present in the Section 1 analysis. So my question to you is with that in mind, oh, there's my time. I'm sorry, Brian, I'm gonna go a little bit over. So my question to you is this framing, those couple of quotes that I just mentioned, is that how you see the maxims that you're proposing? Because otherwise the maxims seem to me quite narrow and maybe overly specific, and the kinds of things that, like you had mentioned before, may be easily strategically avoided in the way that a government writes its regulations, or a court could strategically avoid in actually having to face to invalidate government legislation. And if it is, then I think that's wonderful that you're looking to highlight the tensions or to revive the tensions between principle and context in the limitation rules. And I think that if you put that more front and center in the way you describe what these maxims are meant to do, which is to say that they need to draw attention to the structural readings of the Constitution, and putting those front and center, I think would be really helpful to emphasize what it is they're doing. They're not just a mechanical way of sort of quickening a Section 1 analysis, but it's a way for us to force the court to turn its attention to and articulate again something about its understanding of the Constitution when it's doing the Section 1 interpretation. Now, I'm just going to take a quick moment to speak to Hoy's piece as well. So this puzzle that you're describing between Section 15 and Section 1 is fascinating. Now, I know that you're in the early stages of developing this paper, and what I would like to hear you speak to, I'm not sure if you have this prepared for today, is you're tracking what seems to be a movement from what was present in the Section 15 analysis around arbitrariness and moving that into Section 1. Now, this seems to follow, like I've talked about with the other papers, a fairly common theme in Section 1 analysis, where let's get past the infringement quickly so we can get on to balancing. Now, do you see that? Would you see this movement of Fraser as sort of following in line with that judicial desire to move everything into Section 1? If so, would what would the effect be then on section 1 analysis for a discrimination infringement or a violation of section 15? Would it strengthen or raise the standard for justification required by the government under section 1, which may sort of address the question you raised as an interpretive problem around whether section 15(2) would become an obligation under analyzing whether section 15 there was a violation present there. So that'd be one question, is what would be the effect of actually shifting arbitrariness very clearly and definitively into section 1? And then the other question that is raised to me is section 15 seems to come up most often, at least in my world, around as a balance against other types of rights infringements. Now we see this, for example, in the Law Societies of British Columbia and Trinity Western University decision of the Supreme Court, where discrimination is used as an interest in the charter that's balanced against the rights of religious freedom of Trinity Western University. And so the question that I would have as well is whether you could comment on how the Fraser movement would affect the way that that balancing occurs. And how would that balancing occur if we preserved a pre-Fraser place for arbitrariness in establishing a section 15 infringement to begin with? Now, I'm sorry, I probably went 3 or 4 minutes over, but I don't know, is somebody going to moderate the questions, Brian, or should I moderate that?
Yes, we will moderate the questions, and we do have a few, but maybe we'll let the panelists just respond to some of those comments, and then we'll have some Q&A.
Go ahead.
Okay, I hope I can be brief, mainly because I can't read my writing. Just on the question of customizing section 1, the approaches under section 1 for specific rights and guarantees. I guess, the Oakes test was never able to function as a monolith. And I suppose my view is that if I am able to be specific and concrete enough about how the analysis of breach works under section 2B, then that will provide guidance under section 1 on how the section 1 analysis can be sort of customized to respond to the requirements of section 2B's guarantee of expressive freedom. I have to go fast here so others can speak. Number 2, proportionality, balancing a false promise. You bet. That's why I recognize that for my idea to work, there has to be some structure built into it. And I am working on it. I could say more, but I'll leave it at that. Just I'm happy to speak to you after, just because I want to leave time for others. And third, on the question about harm, I guess all I would say is that it's not realistic or right in principle to insist on a concept of harm that is strictly causally based, like a direct relationship between cause and effect. But that said, I do think that the court and the jurisprudence can do much, much better than it does in identifying a theory of harm that can support limits on expressive freedom. I'll stop there. Thank you very much.
So thank you for these really helpful comments. I'll just say 3 quick things in response. One of those is that I actually hope that governments will avoid the application of principles from the Oakes test by not putting in appropriate limits on rights and freedoms. So if there can be clear rules that enable them to do that, that would be good. But I appreciate very much the implicit critique here that it's important to have maxims that aren't subject to strategic evasion in some inappropriate way of the sort that I suggested may be possible in some contexts for the Oakes test itself. So I'll consider that. And my third comment is that I'll reflect more on the connection between these maxims and the broader principles. I agree that they could be informed by those broader principles, but in part, I am trying to offer some implications that can be used easily so that not every case has to go to a full record in quite the same way. So I'll think on that, and thank you very much for the comments.
Thank you, Blair, for your questions. Obviously, despite Brian. Just kidding. Yeah, so your first question is a question about the movement out of 15 into section 1, which is possibly consistent with other provisions of the charter. So let me say, I think there are sort of two possible significant consequences, right? So the first is almost kind of rhetorical, right? That is, if government is constantly having to defend itself against the claim that it has discriminated, right? And this goes to something that Greg Weber has written a lot about, but is justifying discrimination. That seems to be put governments in a lot of sort of uncomfortable situation, right? And we see this reflected in the jurisprudence when courts under section 15, like under section 7, say we should only justify in exceptional circumstances, right? So there's this rhetorical concern. There's also a burden of litigation concern. And that is, if every difference between a claimant, an enumerated group, and their condition and the wider society is subject to a section 15 challenge, the potential for litigation is enormous. Right, so you can think of virtually any benefits regime will have some kind of, will likely have that kind of effect. So there's a rhetorical concern, there's a kind of burden of litigation concern. Your second question was about the balancing of other rights, right? So the first thing to say is that the cases you're pointing to don't happen under the section 1 framework, right? So that they happen under the Doré framework. But if you have a kind of more restrictive or a more stringent section 15 test, a stringent analysis under the equality rights, part of the Doré analysis, then I think what you will have is a recalibrating of the balance, right? When the different rights are balanced one against the other in a situation like LSPC. Great, but thank you so much for your questions.
Thank you for that wonderful discussion and for those comments. And we'll just get right into the Q&A here. And we'll start with a question for you, Professor Kong. I think jumping off from that response, what role do you think section 1 will play in section 15 analysis in the future, putting aside theoretical concerns with the status quo? And the question was, do we get any clues from Justice Kazagir's concurrence in CP or his questions in Sharma, where he suggested that section 1 is a way to reconcile Fraser with many of Fraser's observed theoretical and practical problems?
Yeah, I mean, so this is one way of doing it. So you could take section 15 and section 1 and hold them in a kind of relationship that, say, section 2A or section 2B stands in relation to section 1 and put sort of all the analytic freight under section 1. So I think that's entirely possible. And I think that you could resolve some of the problems around section 15 by just basically moving everything into the justification analysis. I'm not sure that necessarily responds to a concern like the sort of my responses to Blair. That I'm not sure that responds necessarily to the concern about the sort of rhetorical effect of the government constantly defending claims that it has discriminated. And I'm not sure it reduces the burden of litigation problem. Although over time, maybe you develop a robust section 1 framework that does do that.
Good. Do any other panelists want to comment on that point? Okay, next question for Professor Newman. Is there merit in having a special Oakes type test for constitutional injunctions? So you mentioned, for example, immediate constitutional questions such as church closings 3 days before Easter. Does the law of injunctions need modification to allow for a different threshold, perhaps informed by a modified Oakes test?
Well, I mean, the law of injunctions in some ways already applies an implicitly modified Oakes test just in the way in which it's applied. It's just, it becomes one that's not necessarily so effective. But could there be a modification in the law of injunctions in some way to be responsive to these concerns? Conceivably, and there'd be an argument for doing so insofar as the law of injunctions developed in common law contexts and wasn't necessarily designed to be tuned to constitutional rights and freedoms in every context in which it's applied. So there could be some thinking there. It hasn't been what I've essentially been addressing, but I'll think some more about it. And I guess I'd just say that there's some possibility there. It's an interesting question to raise.
Professor Cameron, you argue for a more robust analysis of the severity of the infringement occasioned by the Section 2B breach within the 2B analysis before moving on to Section 1 in order to avoid sending an empty finding of breach to the Section 1 justification. But the question here is, doesn't the same analysis already happen presently under the proportionality breach, under the proportionality branch of Section 1, which does balance deleterious and salutary effects, isn't appreciating the real cost of the breach already weighed just under Section 1 directly, rather than Section 2B. Essentially, why does it matter that we do this work at the breach stage instead of at the justification stage?
Thank you for the question. I would argue that it doesn't happen under Section 1 in that deleterious consequences, salutary benefits analysis. And I would say that in addition that the Section 1 analysis that takes place under the auspices of the contextual approach already so weights the analysis against Section 2B and expressive freedom that it has no chance whatsoever. I can think of many cases where the court has said under the deleterious consequences, salutary benefits analysis that the expressive content has little or no value, and therefore the salutary benefits clearly outweigh. So I also think that from a conceptual and methodological point of view, that the analysis of breach has to be completed the right way as a matter of principle. And to send just an empty finding of infringement to Section 1 does a disservice to the guarantee of expressive freedom and to the concept of freedom itself. So I actually think that you can't, well, I shouldn't say you can't, it would be very difficult to arrive at a sound method of justification analysis under Section 1 without a robust approach to Section 2B to start. So I hope that answers the question.
Very helpful. So then a question for all three panelists, and this was alluded to by Professor Major as well, which is currently we have the Oakes test, which applies essentially equally to all rights and freedoms under the Charter. Should there be different tests that are rights specific? Should there be a unique consideration for the Section 1 analysis for Section 15, for example, that might not be a consideration under 2A or 2B and vice versa? So on this panel, Professor Kong, you spoke to Section 15, Professor Newman primarily to Section 2A, Professor Cameron to Section 2B. Do you think there are unique considerations for each of those respective rights that ought to be basically hardwired into the Section 1 analysis, unique to the consideration of those rights?
So I think, in some way, we already have variants across the provisions under Section 1, right? So when we think about Section 2B, right, the levels of deference accorded to different kinds of speech, but quality of speech. Under Section 2A, the place that mandatory as opposed to voluntary obligations plays in 2A as opposed to Section 1. So I think part of the answer is we already do have variants across the different rights. Speaking specifically to Section 15, I think that there will be, if arbitrariness is sort of brought back into Section 15, there's going to have to be some serious consideration about the difference in arbitrariness under Section 15 and under the rational connection part of Section 1. I think that in some instances, there will be kind of a duplication of analysis in the way that there is under Section 7 with the principles of fundamental justice and arbitrariness, but in some cases there will be a distinction. So not a different analysis, but a different set of issues that might arise under Section 15.
And I would agree with Hoy that in some ways we already have this, we just don't always admit it. And if one looks at the jurisprudence on particular rights and freedoms, sometimes that jurisprudence is mainly about Section 1 as applied to that right or freedom, more so than about the right or freedom itself. But there may be reasons to more explicitly acknowledge this, in part because it could lead to more principled adaptations of the Oakes test to the different contexts. And one can consider others that have some similarities to those that have been mentioned. If one talks about language rights, there are many group interests at stake there in a way that there aren't in the same way, say for expression, but there may be in the context of at least some types of religious freedom claims. And so thinking of some of the different categories across different types of rights and freedoms might drive principled ways of adapting the Oakes test in different contexts, but ultimately it already is happening somewhat right by right, as Hoy has suggested.
I guess I would say that the nature of the breach should find its way into section 1 in some way, so that if it's a section 15 breach, that finds its way into section 1 in a particular way. If it's a section 2B breach, it finds its way into section 1 in a particular way. And I think that is very important. I guess with reference to section 2B, I think that the interference with freedom will be more or less spurious by reference to section 2B's underlying values, but that to my mind is a different thing than measuring specific content against abstract values, because I think that's an unfair comparison. And I guess the last thing I would say is that I'm put a lot into deleterious consequences as the place where I would find section 2B's interest to be customized in section 1. And I sort of had an oops moment where I remembered that many years ago, I also at some point suggested that there should be something at the start of the section 1 analysis that would reference and acknowledge the specific nature of the infringement, and that could be for section 15 or section 2B, but it would be the setup for the section 1 analysis. That's sort of been lost in the mix over the years, but it's, and I think probably because it's a little bit amorphous, but I do think that the idea that Oakes could somehow function identically across the Charter's rights and guarantees is completely unrealistic, and it has not been the way of the Charter's evolution.
Thank you so much. A couple of questions touch on this theme of evidence and weighing of evidence under section 1, and some of them are in the context of COVID related litigation and challenges, where concern has been raised that courts are relying not directly on evidence or examining the evidence directly, but relying on decisions of health experts and deferring to them. Do you have any comments on the role that courts should be playing in terms of directly examining the evidence versus to what extent is it appropriate for them to defer to the expertise of administrative decision makers, or in this case, health experts specifically? So kind of specific to COVID, but I think it has general application as well for this whole question of demonstrable justification. What is demonstrable and what does that require? Maybe I could ask you to speak to it first, Professor Newman, just in light of the COVID.
This is a little bit one of those in 30 seconds.
Right.
Articulate a full theory of judicial deference kinds of questions. I mean, obviously, one does want judges to be able to look at evidence. At the same time, there will be lots of settings where they're institutionally not well set up to consider evidence in the same way that legislators can. And they need to exercise caution on doing so in a way that would intrude. And on COVID specifically, I would say part of what probably factors into it is the point of time during the pandemic at which they would be doing this. And it's riskier to start making bold decisions that interfere based on a potential reading of the evidence at an early point. Maybe down the road it becomes easier, but there still needs to be a respect for the institutional capacities of courts on some of these things. And so some pretty challenging questions here to wrap up in 30 seconds. Yep. So I'll leave it at that.
Any other comments on that question? So last question then will be this. We're celebrating, commemorating the 40th anniversary of the Charter. Thomas Jefferson once said that the Constitution needed to be rewritten every 18 years so that the next generation could make the Constitution their own. So we're now 2 generations into the Charter, but we do have a number of emerging scholars here today, a number of law students. Just by show of hands, how many here are law students today? Fantastic. What a great way to spend the week after exams is talking about law students. Think about the, the, so to speak, next generation of charter jurisprudence. What do you think are issues that emerging scholars might want to closely examine in the areas of the relationship between Section 1 and fundamental freedoms or equality rights? There's another great 30 seconds or less question for you.
I have a cop-out answer, which is that one of the things that has been most interesting to me in the last few years is the renewal and regeneration that we've had in some of the patriation and early charter scholarship. And I would just point to two particular areas where there's just been an amazing regeneration and renewal. One of them is just on the whole business about amending the Constitution. We all went into radio silence after the Charlottetown Accord failed, and yet now there's a very robust interest in issues about amendment. I give some of the credit for that to Richard Albert, but that's one area. The other area is, the override. And so the override has been always, has never been quiescent, but what we see now is a real re-engagement in the scholarship around the override. And I think those are very healthy developments, and there's no reason they can't extend across a range of charter rights and guarantees and issues.
There are many different things we could highlight, because even being 40 years in to the charter, there are many unexplored things. One of those, obviously, that I've argued for before, along with Derek and Brian, is for attention to matters related to what can be called the forgotten freedoms, those that haven't received much development as yet. On each of those, there needs to be development of the content and of the approach on Section 1 to that freedom that hasn't received much case law or much scholarly engagement. Another area I'll flag that's totally separate, it's making its way up through the courts, but the relationship of Section 1 and other aspects of the Charter to the actions of Indigenous governments and the interplay of Section 25 with all the rest of the Charter. There's some big challenging questions ahead there where I think people might not be comfortable with some of the consequences that could come out, but where there may be principled reasons to accept those anyway. And so just some very challenging questions so ahead in that area. So if there can be scholarship that informs that by emerging scholars, that would be great also.
Yeah, maybe just a kind of large picture, big picture relationship. And sort of Jamie raises around Section 33, the relationship between constitutional politics and amendments, actually, the relationship between constitutional politics and constitutional law. That is, Section 33, I think, really highlights that concern. Within Section 15 specifically, I think there's an emerging understanding of what we understand to be vulnerability that deserves recognition under Section 15, whether under the enumerated grounds and understanding what different kinds of vulnerability emerges for some groups and possibly under an expanded analogous grounds doctrine. Yeah.
Professor Major?
Yeah, so one of the other questions I was going to ask the panelists, but I didn't because I know we're talking about it later today, is what seems to be, it's maybe not fair to say, but I think in some ways it is true, the dwindling importance of the Oakes analysis as modern governance continues to move more and more into the administrative sphere. A lot of the questions that we talk about today, I think sort of in the background in my mind is, okay, so that's great for Section 1 and Oakes analysis, but how do you envision that applying if we're now in a administrative context, and especially some examples that were raised around the COVID regulations and things like that were an administrative decision. And so, I mean, it imports a different, or it invokes a different kind of analysis, but it's meant to echo what's done here. And so I think that that's a really important area of scholarship. That's a really important thing for us to continue to turn our minds to as scholars and lawyers, is how do we, and maybe in some ways articulate again and again for ourselves in any context where the charter is being brought to judicially review the actions of the government, the kinds of foundational questions that I think Professor Newman raised really well as his infant self that every opportunity we have to do that, we are reinventing and speaking to ourselves, again, those deep commitments to the Constitution. So this is another quote, but I'm going to go beyond a reference to purpose in the development of a formal mechanical test to say that our vision of the constitutional structure should pervade our minds and hearts each and every time we consider limits on rights. I just really like that phraseology. So I think that we have an opportunity to rewrite the Constitution in some sense, re-articulate for ourselves what it means every time that we're litigating these things. So I think thinking forward to these issues and how they're going to apply moving forward it's ripe for continued movement in how we protect and limit our rights and freedoms.
Fantastic note to end a fantastic discussion. Will you please join me in showing appreciation for our panel? All right, well, we're off to a great start. Wasn't that a great morning? And we're going to take a quick break, 10 minutes, but we do have coffee and muffins set up right behind us here. So please make use of that. We do want to be back in the room at 11 a.m. sharp for our next panel. So please do be timely and punctual, and we look forward to that next panel. Thanks very much.
We'll get started shortly, everyone. I'll ask you to make your way back into the main room. Hope you've enjoyed our break. We have an excellent panel coming up on reconceptualizing limits on rights. So please make your way back into the room as you can, and we'll get started momentarily.
I'll be here later. Okay. Of course, it's
Thank you, everyone, for a wonderful morning, a wonderful start today. First with Justice Lowers, and then with our previous panel, we're now very much off to the races, and we're going to keep going, continuing now with an all Zoom panel, an all-star, star-studded Zoom panel featuring Professor Gregoire Weber, who is a Canada Research Chair at Queen's University at the Faculty of Law. And as I just noted, as I was looking at his bio again, a former clerk of Justice Biddy. So wonderful to have her here. We also have Professor Lorraine Weinrib, Toronto Faculty of Law, joining us. And we have two wonderful discussants. We have Professor Jeffrey Sigalet, who is at the University of British Columbia, Okanagan, Professor of Law and Politics, and Professor Kerry Frock, an Associate Professor at the University of Brunswick, Faculty of Law. And the title of this panel, again, is Reconceptualizing Limits on Rights. So we'll be thinking about, of course, Section 1, kind of digging into the Oakes test, the framework for Section 1, but also a 40th anniversary symposium on the Charter would not be complete without a talk that features the notwithstanding clause. And we'll have some talk on the notwithstanding clause by Professor Weinrib. So I will hand the floor to Professor Weber. And actually, first of all, please join me in welcoming our panelists.
Thanks very much, Brian. It's a failure of the first order to conceive of a rights limitation as infringing or violating a right. And that is the basic idea I hope to explore with you today. The failure, I say, is on full display in the Supreme Court's most famous decision interpreting the Charter's limitation clause. By affirming that rights are subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society, our limitation clause closely tracks the Universal Declaration of Human Rights, wherein rights are said to cohere with duties owed to other persons and to the community. Yet such an understanding of rights is missing from the court's decision in Oakes. Instead of understanding the limitation of a right as the right's scope and content, the court equates limitation with infringement and violation. It was a profound mistake for the court to do so, and by exploring the relationship between rights, their limitations, and our relationships to others and community, we may explore what the court should have said in Oakes. And to do so, I begin by returning to the Universal Declaration of Human Rights and its conception of the human person. The Declaration begins by affirming the shared conscience of mankind and our membership in the human family, a membership that extends to everyone without distinction of any kind. And in addition to the human family, the Declaration also insists on what it calls the natural and fundamental group that is a person's most immediate family. Between one's membership in these two families, the Declaration also situates the human person in association with others, in community with others, and as a member of society. All of these references to the human person's relations to others are then in turn situated in a social order, which helps to frame the idea behind the Declaration's many references to the protection of the law. Emerging from the Declaration is an understanding of human rights that are to be protected by the rule of law, so that by the time one reaches the Declaration's penultimate article, it comes as no surprise to read that the free and full development of human personality is possible not only in community, but more forcefully only in community. The truth of the indispensability of community for the realization of our rights is approached by understanding how the development of human personality requires a range of opportunities. And few such opportunities are givens, and almost all require the human activity of many. Every one of us, as the Declaration, is to contribute to such activity. We all have duties to the community in which alone the free and full development of human personality is possible. Such duties are not opposed to rights unless we conceive of our rights without holding in view other persons as fellow members of the human family. But any such self-interested conception of rights is repudiated by the Declaration's reference in its very first article to how all human persons are endowed with reason and conscience, and all are to act towards one another in a spirit of brotherhood. This spirit of friendship is a requirement of reason and conscience, and it rejects any conception of rights that would allow for an unqualified ranking between me, the one who matters, and you and all others who are not me, and for that reason make no claim on my conscience. No conception of rights is to be admissible if it denies one's duties to the community, opposes human persons to each other, and denies that it is only in community that one's rights are most fully realized. And yet, that is the conception of rights at play in the case of Oakes. In the dozen or so charter cases before the case of Oakes, the Supreme Court offered some remarks on the limitation clause, on the need for a more than minimal evidentiary record to entertain the justification of a limitation, on rejecting utilitarian reasoning for such justification, and on distinguishing a limitation from an amendment to the Constitution or from an exception to rights. The court reasoned that if a rights limitation meets the test set out in Section 1, then the Charter has not been violated. But in the year before its most consequential decision for the limitation clause, the court begins to substitute the words override and impair for the limitation clause's limits. And then comes the case of Oakes. In framing the constitutional question before it, the court asks whether the challenged legislative provision in the Narcotic Control Act violates a section of the Charter, and if it does, whether despite such violation, the legislative provision is a reasonable limit. The implication is that it can be consistent with the provisions of the Constitution to violate one of them, so long as such violation is a reasonable limit. The court leaves unexplained how it can be reasonable to violate a right and why it is permissible to substitute the concept of violation, which is nowhere found in Section 1, with the concept of a limit, which is. When the court thereafter affirms that the limitation clause's first function is to constitutionally guarantee the rights of the Charter, it is seemingly untroubled by the difficulty that a right guaranteed by the Constitution can be violated with the endorsement of that very Constitution. That difficulty persists in the court's reasoning that the limitation clause's second function is to outline the criteria for justifying the violation of rights, rights which the court recalls are part of the supreme law of Canada. The limitation clause on this reading authorizes the violation of our supreme law. The court further reasons that the guarantee of rights is but a defeasible presumption because limits on charter rights are exceptions to their general guarantee. Yet the text of the limitation clause makes no appeal to presumptions or exceptions, and it cannot be read to sanction the court's appeals to the vocabulary of override, violation, infringement, and impair, as though all such terms are synonyms of limit. The court's reasoning is a far cry from the Universal Declaration's call for human rights to be protected by the law, and that instrument's injunction that human rights are never to be disregarded. Yet there is a silver lining in the case of Oakes, for in its brief interrogation into the idea of a free and democratic society, the court comes close to repudiating its mistake. The court reasons that the very purpose for which the Charter was entrenched is that society is to be free and democratic. That it is a significant affirmation, for it situates community and its aspirations to be free and democratic, and not rights and freedoms isolated from community, as the reason for which the Charter was adopted. We are here approaching the Universal Declaration's understanding of the indispensable role of community for the free and full development of human personality. The court approaches even closer to the Declaration's conception of the human person's need for others and duties owed to them when it articulates the values and principles essential to a free and democratic society. Respect for the inherent dignity of the human person, commitment to social justice and equality, accommodation of a wide variety of beliefs, respect for cultural and group identity, and faith in social and political institutions. The human person is now situated not in opposition to the community, but rather as a full member of a community in pursuit of justice and equality and human dignity for all. The court's insight reaches its apex when it articulates a fundamental truth. The underlying values and principles of a free and democratic society, it says, are not only the ultimate standard for evaluating rights limits, but are also the genesis of the rights guaranteed by the Charter. The values and principles of a free and democratic society are the genesis, the source, the origin, the foundation, the very basis of our rights, it says. There is here a rejection of any fundamental opposition between the person and the community, and affirmed in its place is a conception of the human person that acts towards others in a spirit of friendship and their shared pursuit of justice and equality, a conception of rights that respects the inherent dignity of every person, and a recognition that none of the opportunities for the free exercise of rights can be realized without the efforts of many aided by social and political institutions. So what then should the court have said in Oakes when it interpreted our limitation clause? It should have begun and ended with its insight that the underlying values and principles of a free and democratic society are both the genesis of the rights and the ultimate standard for a rights limits. In between this first premise and conclusion is a complex pair of ideas. Rights are superior to law insofar as any unreasonable limit is a violation of rights, and yet rights require law for their full realization. Therein lies, in summary form, the whole of what the court in Oakes should have said. The rights guaranteed by the Charter are in need of laws constituting limits. A right's reasonable limits is the specification of the right's scope and content, without which there is no right to speak of. A right without limits is a right without boundaries, without scope, without the frontiers within which the right holder acts. Rights are fully specified, are fully constituted by their limitations, are fully directive of right action when they specify and settle who owes what to whom. By holding in view the truth that every generally formulated right must be subject to reasonable limits that are prescribed by law, the limitation clause calls on the legislature to be a full partner in the realization of rights in community. Every reasonable limit is a further specification, a further limitation, a further demarcation of the scope and content of rights left incomplete in the Charter itself. Let me conclude with two thoughts. The first is this: what the court should have said in Oakes was said 33 years later by some members of the court in the case of Frank, when they affirmed that a reasonable limit does not justify an infringement, but rather is inherent in the right itself, shaping the right's outer boundaries. My second concluding thought is to thank Brian and Derek for the opportunity to lend some support to a further thought expressed by some members of the court in Frank, namely that to equate the limitation of a right with its violation distorts our constitutional discourse, distorts our understanding of rights, and perhaps most fundamentally, distorts the legitimate boundaries of legislative action. Thank you.
For your presentation, we will move on to Professor Weinrib. Professor Weinrib, the floor, and the floor here is yours.
Thanks very much for the invitation to participate today. And I'm thrilled to be on the panel with Gregoire because he and I have been celebrating the 40th anniversary on a number of occasions in the last few weeks. And this is our first opportunity to appear on a panel together with papers which will invite, I think, interesting contrast and I hope deliberation. The Canadian Charter of Rights and Freedoms entrenched a duty on the state to respect and protect the equal and inherent dignity of all persons subject to its authority. To fulfill this duty, certain adjustments and amplifications of institutional roles subject to the Constitution were required in order to create justiciable protection of fundamental rights. In this short introduction, this short presentation, I'd like to set out some background as to how the particular features of Section 1 entered into the charter text and the constitutional structure. I want to identify the heritage that these features exemplify. And I want to suggest that this model of rights protection requires further crystallization and implementation in our institutional systems and in our personal lives as free and equal persons and right bearers in order to fully secure and to protect and continue and maintain the promise of the Charter. The historical heritage that the Charter crystallizes includes, as Gregoire has mentioned, the Universal Declaration of Human Rights. But of course, it actually goes back further to the Enlightenment recognition of the sovereignty of the individual. And we see strong elements of the beginning of that being formalized in public policy and law in the Declaration of Independence of the United States, which was not a rights protecting instrument, of course, but more fully in the almost contemporaneous Declaration of the Rights of Man and the Citizen, the French document that has very clear elements of the Oakes arrangement and analysis embedded in it. The Universal Declaration, of course, is itself not a rights protecting instrument, but it generated rights protecting covenants, which also have rights guarantees and the basic features of the Oakes tests. And the covenants generated regional instruments, post-war constitutions at the end of the war for failed states, for reconstructed states, and actually transformed the constitutional arrangements of the victor states. And then we have the stage that Canada entered this model. I call this the post-war stage. Canada's single limitation clause and its formulation, as well as the Oakes analysis, became a sensation in the world of rights adjudication. It inspired the framing of rights and justified limitation in the Israeli and South Africa constitutions. And I was honored to be a person who participated in some of the export of the Canadian model to those countries. And the Oakes test is cited and incorporated and admired in almost every rights protecting system in the world today. And there are a statistical analysis to show that at a certain point, it had far outstepped the previous adoption of American precepts into constitutional law. So Canada became the model, both in its text and also its adjudicative structure. So how did we get Section 1? Well, interestingly enough, we didn't get it from the federal or provincial government. The provincial government had submitted a proposal which said that the rights would be subject to reasonable limits, generally acceptable in a free and democratic society with a parliamentary system of government. The generally acceptable and parliamentary system of government references were identified by many as just continuing legislative supremacy and ordinary majoritarian politics and not entrenching rights. And that's not a surprise because the provinces that drafted that penultimate version of Section 1 didn't want a charter. And so their purpose in drafting it with the words generally acceptable and a parliamentary system of government, excuse me, was to maintain the status quo. The charter, as we all know, replaces that deferential language with prescription by law, demonstrably justified, and in a free democratic society. What's the difference between the two models? Well, the provincial model invited the courts to consider whether rights had been encroached upon or whether there was a recognizable claim to a right and the fact pattern presented. And then consider the limits as with reference to an open system of considerations, all things considered, interest balancing. Of course, it's very hard for courts to use their strengths and methodologies to do open-ended balancing. And this model was rejected for exactly that reason. The Oakes test, in contrast, as I mentioned, is deeply rooted in Enlightenment and post-war constitutional framing. It elevates the rights over ordinary preferences. It doesn't invite interest balancing. What it does is encapsulate as possibly standing prior to rights, the whole system of rights protection, the values and principles that inform the rights, so that no particular right is absolute, but the whole system of rights protection prevails. That's what rights protection is. Beyond this larger sphere in which the particular rights are encased in this whole system of rights protection, protecting equal and inherent human dignity in the abstract, and other values consistent with that aspiration. We have ordinary politics. So the legislatures are constrained because there's a duty on the state to protect the rights, but the individual rights aren't absolute. They yield to the principles of limitation as the court in Oakes so eloquently described them, and Gregoire just repeated for our edification. How did this final version of Section 1 enter into the text? It entered in a very interesting way. And it's really the answer to a question that puzzled me for years. As I studied this model and saw how it entered into other constitutional systems in the 20th century, I saw, failed state, defeated states, or the victorious states realizing that they had to eradicate the racism and religious prejudice, et cetera, for which they had won the war, executed the war. So the interesting thing about the genesis of Section 33 is that it occurred in a special joint committee that the Liberals were forced to mount at the insistence of the Federal Conservative Party. Federal Conservatives wanted the joint committee proceedings to interrupt and hopefully delay the charter project enough so that they would reach the next election without the charter being entrenched. Nonetheless, the Joint Committee took on a life of its own. A grassroots slow motion revolution that had started in Canada immediately after the war to hopefully bring Canada into compliance with the Universal Declaration of Human Rights and the international human rights revolution generally, had done an enormous amount of research, organization, fundraising, and met with success here and there in getting progressive legislation passed. This movement also funded and guided test case litigation. And this slow motion grassroots project had become so sophisticated that by the time in 1980, this Joint Committee was structured, they just were, it seemed from nowhere, produced a juggernaut assault on this deferential penultimate limitation section that the provinces had put forward. That their work enriched and multiplied the rights. It gave a right to go to court and for just and reasonable remedies in the circumstance. It brought in the multiculturalism clause and the women's equality, gender equality clause, sponsored by the women's movement. And they drafted Section 1 word by word. This was, of course, a dynamic that the federal government was very receptive to because they had wanted a strong charter with a stringent normative limitation clause, but couldn't get the provinces to agree. Now, the interesting thing about this Joint Committee, which went on for more than 200 hours and had hundreds of submissions, and much work by academics who worked with these public interest groups to present their positions and their history of terrible disadvantage and deprivation in Canada to the committee in an effective way and in a way that would be helpful to drafting the charter. The result was that the charter project attracted sky-high popularity across the country. The Conservatives had not only insisted on the Joint Committee, they had also insisted that it be televised. And it was fabulous television. There were all these very, very interesting groups bringing forward their history in Canada, their challenges, and not complaining and not being bitter. This was one of the rules of this movement, but to join together in a more generalized, abstract claim about what was wrong with ordinary politics and social, economic, and political hierarchies, and why the solution was to institutionalize in Canada as supreme law the respect and protection of all persons subject to law. Now, of course, we all know that the reaction to this stringent version of the limitation clause prompted the provinces to demand Section 33. But the important point is the incredible legitimacy of this process made it impossible for the provinces to continue to bargain to take out certain rights or weaken the rights or have a more differential limitation clause. That's where we got Section 33. The charter project was legitimated so strongly by the people of Canada, the people in Canada, the We the People movement, these social groups embody, that the provinces had to relent on the charter. Now, one can say that the Joint Committee's work was the first popular constituent assembly that Canadian history had ever offered to ordinary Canadians. The final compromise of the override was not an illegitimate compromise. I think it was a principled compromise, as long as the override is acknowledged to be what it is, an exception to the strongest norms in Western history, encapsulated as supreme law, the respect for the inherent dignity of all persons. Now, I'm not going to say a lot about the override. I just want to say that reading the override strictly means going back to the actual terms. I actually argued the major override case forward on behalf of the province of Ontario in an earlier part of my career. And I argued that the court had to read the text. Unfortunately, the court was not careful about reading the text, and neither was it reading Section 33 strictly. But I'm not going to pursue that in great detail here. I just want to say that the text says what can be overridden is a provision, not a section. And that would produce a better legislative process if the debates on adopting the notwithstanding clause had to actually acknowledge that there is a violation of, or the potential of a violation of a particular right, because then the people who hold that right have greater standing in the legislative debate. There's also the sunset clause, of course, and the bylaw stipulation. I think that one thing that should be strongly pressed, and the general public can do this, in the situation where overrides are under consideration, is there must be full deliberation with committee hearings that include experts and the people who are affected, and they should have the full length of normal debate. They shouldn't have closure imposed on them. They shouldn't have the spectacle of evening and weekend hearings as we had in Ontario for the City of Toronto election override, which wasn't implemented, and clearing of the public gallery because there was too much noise. And then we had a similar fast track, non-deliberative legislative process for Bill 21. And I think in both instances, it was because opposition was building. So we have to get faster in implementing opposition, but also slowing down the legislative process for the override. And finally, the point that Section 24 and 27, the multiculturalism clause, have to be factored in to the constraints on the power of the override, and most particularly Section 28, not only because of its own override language, but also because the question of whether Section 28 would be subject to Section 33 went back and forth in the final negotiations, and of course, as we know, Section 28 was won that battle. Now, we see many examples of the erosion of this juridical model and the particularly the features of the Oakes test in recent days. Purposive interpretation has been reduced. This examination of the scope of the right has become less normative. The international and comparative references that the court used to illustrate what it was doing in such a helpful way are being curtailed. And there is suggestion that considerations other than the principles that Oakes denoted as principles appropriate to justification are entering into the picture. The charter created a paradigm shift in giving us a new juridical structure for the relationship between individuals, their chosen and given groups, and the state. We have to work to sustain a paradigm shift we are continue to enjoy as individuals and members of our given and chosen communities, the flourishing of human life that individual rights and respect for human dignity afford. We have to, in effect, continue the spirit of the slow motion grassroots revolution that prepared the way for the Charter and its wonderful flourishing in the Joint Committee. How do we do that? Well, first of all, I think we have to reverse the presupposition that the entrenchment of the Charter was a zero-sum game in which the courts won and the legislatures lost. It was the people of Canada, and particularly the political, social, and economic have-nots who represented the idea of equal human dignity in the Joint Committee so well, who won. The duty that the Supreme Law imposes is on the state, and the legislature and the executive and the courts are the agents of the state to exercise public authority. So nothing has been taken away from the legislatures that it has an entitlement to that is stronger to the change in Supreme Law in form, but also the introduction of these incredibly important human rights principles. Now, I just have a few more points.
Please, to our next speakers. Thank you so much.
There must be much more intervention and participation of the public in the policy-making process. There must, including when Section 33 is on the table. We must have more education and participation of experts to show what is at stake in terms of charter rights when laws are created, amended, and repealed. We must activate as much as we can the voice of the people who have poor enjoyment of rights in the courts. And that means ensuring that charter litigation allows for these weak voices to prevail in terms of the rules of standing, the rules of intervention, the rules of public interest advocacy, and the rules of costs. We need, in a sense, a procedural manual for charter litigation. In that way, and obviously I'll suggest in my paper, we can continue the slow motion rights revolution, which we need to carry on. We didn't win something in the sense that we can now abandon our role as members of the Canadian public, as charter Canadians to a certain extent, to continue the living reality of the Constitution. It's remarkable that the Charter was adopted. It's remarkable that it's as normative and principled as it is. It's so impressive that the courts initiated their Charter responsibility with such fidelity to the values and principles that were put forward in the Joint Committee. But this is a process which we have to sustain. A constitutional revolution is not won in a moment. It's won with the hard work of the general public in ensuring that the legislatures, the courts, and the executive protect and respect our equal and inherent human dignity.
Councilor Carrie Trott, the floor is yours.
Hi there, everyone. My camera view shows a bunch of empty chairs and a podium. So I am going to assume that all of you are sitting there in rapt fascination of what I'm about to say. That's how I'm picturing you in my head, all of you eager law students and maybe some eager law professors, I don't know. But what I am here to do today is to pick up on some of the highlights from Professor Weber and Professor Weinrib's paper to maybe give them some context, how I thought they were meaningful for me, and maybe that will be helpful for you to think about, what to take away from these papers. So starting with Gregoire Weber's paper, what I thought was his central focus was something that I've puzzled about for a long time, which was this seeming tension in charter doctrine. Where does constitutional interpretation of the scope of the right end and Section 1's assessment of reasonable limits begin? And I thought that his paper was really helpful in talking about these two elements together as, kind of two parts of a whole. And thinking about limits that are inherent in the text, which seems to be his phase 1 of limitations, and then talking about what the job is of Section 1, which is more about relational limits, if I can put them that way. And this is really helpful because we see ambiguity in cases like BR concerning Section 7 about parental liberty, and in Section 2A, freedom of religion jurisprudence, both of which talk about the limit of the scope of those rights being harm to others. But according to Weber's approach, that would seem to be more appropriate for Section 1 there. So, and I also thought that his paper was helpful in terms of talking about, this conflict. How can Section 1 guarantee rights and justify violations? In terms of how he made his case for his approach versus the Oakes approach, there's a concept called rights reconciliation that lived a short life in the charter history, which was abandoned. We can see it in cases like Trinity Western, the first Trinity Western case in 2001. And I think the reason that those cases were an abject failure of that approach, because you really had rights conflicts where the reconciliation were the rights of the more marginalized communities reconciling themselves to the more dominant group's rights. So that didn't work. So perhaps, this approach could do a bit of rehabilitation. The idea in theory, I think, was an interesting one in terms of reading the charter holistically. It all has to be read together. So if you have a right, it's not in isolation. You can't use it as a club to kind of bludgeon others. So the question is, though, about Section 1. And looking at Professor Weinrib's paper, I have a lot of time for it in terms of the history shows that it was an attempt to provide some judicial constraints on the way that the judiciary interpreted rights limits. Women in particular spoke of Section 1 as the Mack truck clause, and if we're not careful, it's going to run right over all of our rights. And what they reconciled themselves to Section 1 because they thought there's going to be some limits read in. The US Bill of Rights experience shows us that. The question is, do we want to have judges have carte blanche in interpreting these limits within the scope? Or do we want to give them some constraints in channeling that judicial discretion? And so to some extent, I think Professor Weber's proposal goes a bit against the grain of the history in terms of looking at Section 1 as a judicial justification of what otherwise would be a rights infringement. In terms of some of the things to improve the paper. The thing that I kept on getting caught up on is, why does this matter? Is this a distinction without a difference? And from a feminist perspective, at least, it mattered very much. Whether limits were interpreted into rights or whether the onus was on the government to demonstrably justify limits and to follow the strictures of a free and democratic society. So I think it would help the paper to bring it from the abstract into the concrete. I'm thinking of, for instance, cases like the case that's before the Supreme Court of Canada on section 33.1, the extreme intoxication provision under the criminal code. And to me, if we get, obviously we'll get to section 1 there, but it doesn't seem to me to be a matter of interpreting the rights of a fair trial to take into account consideration of women's equal rights. It seems to be just a brute balancing of the collective interest in making sure that we don't have intoxicated perpetrators offending with seeming impunity, rather than looking at it as the scope. So if Professor Weber could get into some of the thorny issues with concrete examples like that one, that would be very beneficial. The other thing that I think could stand for some clarification is the role of the legislature. It seems, following from its adoption of the frank dissent position, that it seems to give some deference to the legislatures in determining or delineating the limits of rights. And of course, that would be an absolute anathema to the drafters of the ultimate text of section 1, because as Professor Weinrib points out, those terms were very carefully chosen to take into account the fact that legislatures don't often act to benefit people that they don't count on their vote for getting into office. They don't have much political power, etc. This seems to bring back section 1 into what the text originally said and gives no consequence to those textual changes. And I still think that there's some ambiguity in terms of what work is done in section 1 and what work is done in the interpretation. I'd like to see that addressed. In terms, I'll be very quick because I didn't have as much of a chance to delve into Professor Weinrib's paper. But some things that I thought were interesting were the discussion of the deferential analysis that has cropped up in section 1 through cases like Alberta, Hatari and Brethren, RGR McDonald, and it's been kind of a sticking in my side for a long time, the fact that the Supreme Court never really admits when it's wrong. And that's led to a lot of real interpretive snarls. And you mentioned that, but I thought maybe it was worth going into a bit more detail. The other thing I'd ask you to consider is when you're talking about section 33 and talking about it in terms of allowing an exception to the entrenchment of rights, what does that mean for gender equality in section 28? Because we're fighting this in relation to the Bill 21 litigation. If section 33 is an exception, that means essentially that the rights don't exist for that particular period of time, then section 28 has no work to do. And again, that runs against the grain of history. If you take Professor Weber's approach in another paper, talking about just it being a suspension of operation of the charter, I think that gives section 28 a bit more play. So I'll leave it at that. I know I've gone over time, so thanks for your indulgence, but really rich and thoughtful couple of papers, and thanks for the opportunity to address them.
Thank you, Professor Flock. Thank you so much. Over to Mr. Jeffrey Siglet to bring us home. Over to you, Professor Siglet.
Thank you, Brian, and thank you, Derek, and thank you to Carrie and Gregoire and Lorraine for those insightful comments. I'll try to just wrap things up here quick. I should say that I'm going to limit most of my comments to Professor Weber's article or chapter or book chapter or whatever it is ends up being, because I didn't have a lot of time to look at Professor Weiner's piece before this conference. So I've been waiting for Professor Weber's this article for a long time. I've been a long time fan of Professor Weber's theory of rights and conception of rights and his more philosophically oriented arguments about rights, which you can find in books like Legislative Rights or his collection with Bradley Miller and Grant Huscroft on the proportionality and the rule of law. I really suggest that you look into those for some of the more philosophy of law or philosophically oriented thinking about rights that Weber's explored in those books. And so it's really, but for a long time, I've wondered how some of his theoretical insights actually apply to charter jurisprudence. And in particular, I've always wondered exactly how he would characterize Oakes and exactly how he would think about how Oakes should have been decided. The title of this paper is How Oakes Should Have Been Decided, so or what Oakes should have said, sorry, which is just fits exactly what I've kind of always pondered to myself as my question. It's kind of like I never expected him to get into the mud of this question, so it's sort of exciting and a little bit like having your favorite rock star turn into a country star or something like that. Maybe not. Maybe you're not fans of country music. I don't know. So I never expected him to apply his theory directly to Oakes in this way, but here we are. I only have 5 minutes here, which isn't enough time to tell even a half-decent joke. So I'm going to just quickly praise some of Weber's core arguments and the more philosophical aspects, which he reviews, and then ask just a couple of questions. First, about how the holding in Oakes could have been different on his view. And second, whether or not he thinks that even outside of the dissent in Frank, there are areas of charter jurisprudence that may already cleave somewhat closer to his conception of what reasonable limits on rights are, right? So first, let me just review some of the arguments and just sort of wax poetic about how great I think they are. Sorry, Gregor, if this is embarrassing. I think that the text of this paper does a good job at reviewing both the textual and moral arguments that for understanding reasonable limits on rights, not as justifiable infringements, but as specifications of the scope and nature of rights. Textually, just looking at the text, not at the legislative history, not the intention of one subset of drafters, Section 1 does not speak of infringements, but it protects rather limits. And it says that the way the text is drafted, it says that the limits are part of what's guaranteed by Section 1. It doesn't guarantee unlimited rights and then say that those unlimited rights are subject to limits. It guarantees rights subject only to such limits, which indicates somewhat that reasonable limits are part of the rights and freedoms that are guaranteed by the Charter. Limits are not infringements or violations of rights that are separate from a guarantee of just unlimited rights. And look, drawing on his more moral thinking about this, about how to conceptualize rights, he also notes that it's conceptually just inconsistent to say that rights are guaranteed if they're open to justifiable infringement, and if limits are understood as justifiable infringements. Morally, I think that Weber artfully summarizes his view, which I've said is expressed in many of his other writings, like this book, which is also co-authored with Paul Yowell, Richard Eakins, Maris Kopka, Brad Miller, and Francisco Urbina, Legislative Rights. he reviews his argument there that the idea of justified infringements severs rights, and conceptualizing reasonable limits as infringements that are justified severs rights from a consistent connection with justice. If rights are just these prima facie interests that are infringible with the adjudicative blessing of courts, then they don't specify what is right, what should be done, what duties we owe, and what obligations we have between each other in a political community. And that's a big problem. If rights are part of justice, they can't just be a first step to evaluating what should be done in a political community. They have to be the conclusion, what you are owed as an individual, as part of this group. I think that there's a really interesting way in which this essay highlights a communitarian edge of this way of thinking about rights. And to that end, it draws on Charles Taylor's old essay, Atomism, which is a very well-known essay in philosophy and the social sciences, where he draws on this paper to show that the idea of rights as just these unlimited interests that are abstracted from the community and the relations between persons, in that as if rights are defined in abstraction away from the relation between persons in a political community situated with specific duties and rights specifying their scope, obligations that help specify their scope, then you're contributing to an understanding, a kind of atomistic understanding of society with your understanding of rights in that abstract way. And insofar as you associate rights with choices that are these abstract interests we have, the value of those choices goes down to the extent to which they're not made real or understood properly and specified and fleshed out in relationship to the particular relations we have in a political community. There's also a liberal, there's part communitarian and a part liberal in the sense of respecting individual rights aspect of this way of thinking, because as specifications of what justice requires and its scope and nature, when individuals have rights on this conception, rights have a serious moral weight. They're the conclusions of practical reasoning about what should be done in a political community. They're not just the first step at saying what we should do, and then the community can override them if it wants. They're the conclusion to thinking about how the individual relates to the community in this wider way. And so there's a strong liberal aspect to rights in this conception of rights, insofar as we think that the individuals have certain rights against their communities. And this brings us back to Oakes and the particular situation of David Oakes, who's, as we all know, is found with hashish oil on him and is subject to a reverse onus act that finds him guilty of trafficking with a certain amount of, if he possesses a certain amount of drugs. I think I'm summarizing the case right, just sort of going off my having taught it this year again, in the back of my head. On Weber's view of rights, the understanding of what the reasonable limits on David Oakes's right to a free and fair trial and to not be presumed guilty and to be presumed innocent in criminal law, the limits on that right are arguably just a matter of how we understand the right to be presumed innocence in relationship to a reverse onus provision, which is that there's a direct conflict between those concepts. There's arguably a direct conflict between the very idea of a reverse onus provision of a law that just finds you guilty if certain circumstances just obtain, and the idea that you have the right to be the right to be presumed innocent until proven guilty under a criminal standard of doubt, beyond a reasonable doubt, in those kinds of circumstances, right? On Weber's view of rights, there's no movement afterwards. Once you discover this conflict between, there's no further proportionality inquiry to be done after you discover the conflict between the right to be presumed innocent and the reverse onus provision of the Narcotics Control Act. So in that sense, Weber's conception of rights could strengthen the individual rights claim of folks in situations like David Oakes. Now, my one question about the holding there, though, is to what extent Weber thinks that his concept of rights could potentially justify a different holding. Perhaps the holding that the probability of David Oakes being innocent of trafficking in this situation is just so minuscule low that we think that the right to be presumed innocent doesn't apply. The scope of the right doesn't apply in those circumstances. Is that way of thinking? It seems to me that way of thinking is at least possible on his conception of rights, although he may not endorse it. And I'm sort of taking a page from Professor Frock here and asking him to make more concrete some of the ways his conception of rights could apply to explaining the holding along different lines, but maybe also even explaining how the opposite kind of reasoning might go with regard to the particular case of Oakes. And another query on my mind, despite the nefarious influence of Oakes and its conception of rights as justified infringements on our law, is that it may be that there's it may be, and my question I'd like to pose to Professor Weber is whether or not his conception of rights may be present to some extent in other areas, in specific areas of charter jurisprudence. And my thought is whether or not he might say that Section 8's right against unreasonable search and seizure has been understood in a way that's actually somewhat buttressed away from, or often not couched in Section 1's Oakes test of terms, but often involves a kind of internal idea of what's a reasonable search and seizure within the term reasonable in the terms of the text itself. Is the way the court has treated the Section 8 right against unreasonable search and seizure, has that sometimes played out actually in terms of the understanding of reasonable limits that Weber endorses? So those are my two big questions, and I just want to end by saying thanks again to the organizers and to my other interlocutors here. I've learned a lot from your comments, and I'll just open it up for questions now.
Into our lunch period. What we're going to do is we're going to keep this conversation going for those, certainly for those who are online. We have many people who are attending the webinar, the Zoom webinar online, and for the benefit of Professors Weinrib and Professor Weber to be able to respond to these very rich comments by Professor Frock, Professor Sigalet. We're going to keep the conversation going, but we are officially in lunch. So what I will just say before I go any further is that for those who are panelists and invited guests for the lunch that we're holding here at the law school, I'll invite you to head to the 4th floor. You know who you are if you've been invited to the lunch. That's on the 4th floor. There are elevators just outside. For those who will be grabbing lunch on campus, there are options nearby. There's Great Dane Coffee, which has some sandwich options, as well as Tim Hortons, which is not far away. And then further beyond that, there's the Nest building, which has a lot of food options. So for those who would like to stay to continue hearing the conversation, please feel free to do so. For those who will be grabbing lunch either upstairs or on campus, feel free to do so. We're not taking attendance and keeping track of who leaves and who stays, so don't worry about that. And what we're going to do, just to make sure that we have enough time for you to get lunch, is we're going to have our keynote address by Justice Ian Binney, the Honorable Justice Ian Binney, at 12:45 instead of 12:30. So it was originally going to be at 12:30. It's going to be at 12:45. We're still going to give Justice Binney enough time. It'll be 45 minutes. We have some buffer time on the other end of his talk, so it will all come out in the wash, thankfully. So 12:45 back here for Justice Binney's talk. Feel free to stay if you'd like to hear Professor Weber and Professor Weinberg respond, but otherwise have a wonderful lunch. Thank you, everyone. We'll see you at 12:45. Professor Weber, I may ask you if you're open to continuing the conversation to respond to Professor Sigalet, Professor Frock, given that those comments might be a bit more fresh. So I'll give you the floor, Professor Weber.
Great, thanks, Brian. Well, let me take up Jeff's two questions to me. The first is whether the holding in Oakes could have been different. And he proposes two ways in which it might have been different. And I minded to go for the first with a bit of an asterisk. So what was the first? Namely, that as soon as you established a conflict between what legislation sets out to do and what the charter settles, well, the legislation fails. It is unconstitutional on account of being in conflict with what the Constitution guarantees. So here, the Constitution guarantees the presumption of innocence. And if we read a reverse onus provision as reversing that presumption, well, then it is inconsistent. Now, on Oakes' own reasoning, of course, anything the Constitution says cannot be done can be done so long as it's justified under Section 1. But that's the wrong reading of Section 1, I say. Why? Because Section 1 is about further limiting under-limited, further specifying under-specified rights. And the presumption of innocence, at least with respect to the presumption of guilt, as is a reverse onus provision, is not a further specification, but rather a contradiction. But here's the asterisk. If we read the reverse onus provision not as establishing guilt, but rather as making a reasonable factual inference, it may still be consistent with the presumption of innocence. Now, the facts of the case in Oakes don't help. Why? Because the Narcotic Control Act set the presumption, or the presumption kicked in if you were in possession of any amount of a narcotic. But if we just ramp up the presumption so that it kicks in only if you were in possession of a truckload, it would not be an unreasonable factual inference to draw, right? So if we stay at the realm of facts rather than at the level of guilt and innocence, there need not be a contradiction between the presumption of innocence and a reverse onus provision. Jeff's second question is about whether there are cases other than the dissent reasons in Frank where we find a version of the specification of the scope and content account of rights that I develop. And I think there are at least two, or I'll mention two. The first is the one that Jeff, I think, was gesturing towards, which is a number of so-called internally limited rights. So you don't have a right against search and seizure, but only a right against unreasonable search and seizure. In the mind of some, that's an internally limited right. Notice here when we speak of an internally limited right, no one's a strong claim. Few think that it's an internally infringed or internally violated right. So we already have at play at least an understanding of a limitation on a right as defining the scope and content of that right. But let me mention a second area, which relates to the fundamental freedoms, a set of rights that on the whole are not said to be much internally limited. But I here have in mind the Supreme Court's early jurisprudence that established that violence or threats of violence are excluded from the scope of freedom of expression. I think the court was right to do so, but I also think that the court was not true to method in doing so. You don't exclude violence by way of a purposive interpretation, or if you're minded to think that you can, then I'm minded to say that you don't only exclude violence by way of a purposive interpretation. So there's a tension, I think, either in the court's method or in the court's adherence to that method. But the basic idea, I think, is the correct one, that violence is not a way in which you exercise freedom of expression. No doubt violence can be expressive, it can seek to communicate meaning, and usually those are the triggers for finding a Section 2B infringement, which then goes to Section 1. But I don't think anyone has a right vis-a-vis another to be violent in expressing themselves. And so the court was, I think, right to exclude violence from the scope of Section 2B, but I don't think it was true to method in doing so. I'll maybe just take an opportunity to speak to one of the challenges that I hear or interpreted Carrie as raising, which also feeds into a question that Richard Moon posted in the Q&A, which is partly whether the argument is semantic. In other words, are we merely substituting the word infringement for the word violation or impairment or infringement? Now, on one understanding of semantic, which is maybe the semantics of semantic, yes, at least insofar as semantics is about signifying meaning, signifying truth. So I do think that the true understanding of a right is that a right has to be defined in a way that makes it just to exercise that right. At that level, it is a claim about semantics, about what is being signified by the word right, and so signified by the idea of a right's limits. But more fundamentally, and I think Jeff was pointing to this in his analysis of the Oakes case, it has fundamental shifts in at least some of the way in which we understand rights, among them the presumption of innocence. After the Oakes case, the presumption of innocence is presumptive. It can be infringed, and that infringement can be justified. Under my understanding, the case of Oakes would have been a much more straightforward affair. Insofar as the reverse onus provision is in conflict with the presumption of innocence, that's it. That's all you have to show. There's no question of saying, yes, but it's a defeasible infringement. The infringement can't be justified. A more thoroughgoing analysis of implication would bring us into proportionality. I'll here only highlight that in the Frank case, where we have Justices Cote and Brown insist that the infringement of a right is not what Section 1 is about, but rather Section 1 is about the definition of the right's scope and content, they proceeded to an Oakes test analysis, an analysis of objective, rational connection, minimal impairment, and overall balance. So in their own minds, there was no inconsistency between understanding Section 1 as being part of the definition, scope and content, boundaries of a right, and the shift in burden of proof, shift in burning of evidence, shift in the burning of argument that you have currently under the two-stage steps in the Oakes analysis, nor was there any necessary inconsistency between the structure of the Oakes test and the idea of justifying not a rights infringement, but rather a rights definition. So I'll yield the floor now to Lorraine.
Thank you so much, Professor Weber. And Professor Weinrib, will just turn it over to you for just some closing comments and remarks. And just in terms of a question as well, I'll just put this out to all the panelists, and that's Professor Weber, Professor Weinrib, and Professor Frock. So feel free to incorporate this if you wish, Professor Weinrib, in your concluding comments. But you mentioned Section 28, as did Professor Frock. What role should the Charter's general provisions, including Section 28 and other interpretive provisions, what role should they play in our understanding of Section 1? So I'll add that to the mix in terms of what you're responding to, Professor Weinrib, and then invite you, Professor Frock, to comment on that, and then Professor Weber will just let you conclude.
I'm so delighted you asked that. Because I have had a bee in my bonnet for a long time about Section 28. I don't think Section 28 is an interpretive clause. I think 28 should be Section 1B. So the existing Section 1 would be 1A, and then Section 1B also deals with what the guarantee is. And the guarantee, and so this is qualifying the statement of general guarantee by saying the guarantee, nothing in this charter, it's notwithstanding anything in this charter, the rights and freedoms referred to in it. So it's Section 1B qualifying the general guarantee in Section 1 and 1A. And it's saying that all of the rights have to be read as guaranteed equally to male and female persons. So, and I think this is a really important change, because there's no reason, I think that there are other sections that say the charter will be interpreted. That's not the language used in Section 28. Okay, so what's the consequence of this is that when in any of the sections that delineate the rights, we read in that the right is guaranteed equally to male and female persons. This operates notwithstanding anything in the charter. This is the strongest section in the whole charter. This trumps Section 33. And we don't have to speculate about that, because you can read it, and I lived through it. By day, we didn't know whether Section 28, which was such a triumph of this we the people public constituent engagement in the Joint Committee, the idea that it could be subject to put back, it's so strong in its formulation, and then just taken back by ordinary legislative action seemed bizarre. But so the point is that Section 33 is subordinate to Section 28. Okay, then we have to figure out what that actually means. But I think I would think that it leads to the formation of an argument that when the override is used primarily in purpose or primarily in effect to disadvantage female persons, then the override is void. The override is ineffective to reach into section 28 in such a way as to disable it. That's completely against the text. And also that reading section 33 as an exception means that with just one directive from the Supreme Court, means that you read the powers not liberally, but you read them strictly because they are running counter to the normative structure of the whole instrument. That's the second thing the court says is purposively. Well, one of the strongest problems we have in our society, and any woman living in our society knows this, is to experience in our horizontal and our vertical, person to person and individual to state, experience equal concern and respect for our basic human dignity. And so the idea that contrary to the text, we somehow read section 33 as being able to effectuate such a serious disrespect of equal inherent human dignity, as it does in section 21, seems to me just unsupportable under the charter text. And also, I would reiterate what I said in my remarks before, that the lack of proper legislative debate is also a strong contradiction to the duties that the legislature has to the people to whom it normally owes respect for their basic rights and freedoms, to have such a cavalier and disrespectful legislative process.
Thank you so much, Professor Weinrib. Professor Frock.
Yeah, if I was in person, I'd run up and give Professor Weinrib a big old hug, because sometimes I feel like I'm out there in the wilderness making these points, and it's great to have, you know, an esteemed scholar who was there at the time talking about Section 28. And that's, you know, one of the questions I had for Professor Weber that I didn't really get to is, you know, what's the interaction with Section 28? Because it was very, very clear at the time of 28's drafting that the notwithstanding anything was supposed to be notwithstanding Section 1. And perhaps it makes even more sense with, you know, the theory that he's developing in terms of looking at community interests as the limit, one of the limits of rights that one provides, because that was exactly what women didn't want, is their interests and rights to be subsumed by the collective, because it's always been the case that women have had to sacrifice their rights and interests for the good of others. It's a very gendered position. So women who were fighting for 28 didn't want that. They didn't want women's rights to be devalued or subordinated to those either of the collective or to individual men. So perhaps it makes perfect sense, even if we take a look or we accept or adopt a new kind of structure for the interaction between rights interpretation and Section 1 limitation.
Thank you so much. Thank you so much, Professor Frock. And unfortunately, we are close to our end of time here, that we do have to park this conversation. What a rich conversation it has been. But Professor Weber, I'll just invite you to provide any closing comments.
Well, I'll begin by saying, and I'm sure I speak to every member of the panel, including Jeff, who has had to leave for a faculty meeting, to thank you again, you and Brian for the ability to join you today and to share these thoughts on Section 1. It's just been such a rich debate and a wonderful opportunity to get comments from Carrie and Jeff on the arguments that we develop. I'll end with this thought on the general clauses. I can only assent and agree to what my fellow panel members have said, that Section 1 has to be read with 28. I would add to that the other general clauses on denominational schools, on other rights and freedoms in Canada but not guaranteed in the Charter, and on Aboriginal rights, all of which I think speaks to the need to read the Charter holistically. So this idea that rights can conflict seems very much to be in tension with the messages we get from the general clauses. To take just a recent example, Section 15, we're told, can conflict with Section 2A on freedom of religion, but not with freedom of religion as that's realized in denominational schools. So you have these two understandings of how freedom of religion relates to the rest of the Charter or the rest of the Constitution. If it's denominational school, the conflict's not possible. Why? The general clauses tell us so. If it's other aspects of freedom of religion, the conflicts can be rife. Why? Because the way in which the court has gone about interpreting rights tells us so. I think that the former view is the correct one. The rights have to cohere one with the other, such that each one of us can stand on our rights and respect the rights of others, rather than being in something in a state of nature like a world where we all have rights, but no duties to respect the rights of others. So I'll close there.
What a great note to end on. And will you just join me, everyone, in showing our appreciation for this terrific panel? Thank you so much, Professors Weber, Professor Weiner, Professor Frock. Wonderful discussion, and we look forward to continuing it. For everyone else, we are going to take a break, but we do have Justice Binney speaking at 12:45 sharp, so please do be sure to be back in the room for that keynote. Thanks again, everyone, and we'll see you soon.
Very much everyone for returning after what I hope was a nice lunch, brief I know, but I hope that you were able to get some nourishment and some more fuel for the intellectual nourishment that we're going to continue to have this afternoon. And really excited to have a wonderful keynote address coming up by Justice Ian Binney, former judge of the Supreme Court of Canada. We're incredibly grateful for his presence with us today to offer his reflections on 1982, what that looked like 40 years ago. And we're also very grateful to have a wonderful jurist introduce Justice Binney. I'm very, very grateful to Justice John Hunter of the BC Court of Appeal, one of Canada's, prior to joining the bench in 2017, one of Canada's foremost and finest litigators. And this is not just me saying this, but I told Justice Binney that Justice Hunter would be introducing him. He said, well, maybe he and I should switch places. So really grateful to Justice Hunter of the BC Court of Appeal for accepting our invitation to introduce Justice Binney. So join me in welcoming Justice John Hunter for his introduction.
Well, thank you very much. I was very pleased to be invited to introduce Ian Binney, who will be giving the keynote address to you in a few moments. Ian Binney has, as you know, had a very distinguished career in 4 distinct areas of the law: private practice as a barrister, in public service with the Ministry of Justice, judicial service as a justice in the Supreme Court of Canada, and most recently as a domestic and international arbitrator. He was called to the bar in 1967 and practiced as a barrister in Toronto for 15 years before taking a position in 1982 as Associate Deputy Minister of the Ministry of Justice. It was in that capacity that he was in the room for the birth of the Charter as I expect you will hear shortly. He returned to practice in 1986, was elected a fellow of the American College of Trial Lawyers in 1992, was appointed to the Supreme Court of Canada in 1998, one of the very few lawyers to have been appointed directly to the bench from practice. I mention his election to the American College of Trial Lawyers as an illustration of the regard in which he was held in the profession even before his appointment to the court. While on the court, he authored numerous judgments on a wide range of subjects, including business and commercial law and Aboriginal law in particular. As far as I can determine, none of his judgments were leaked in draft form before publication. Justice Binney was known as a smart, well-prepared, and fair-minded judge. I had the privilege of appearing before him several times when he was a judge of the Supreme Court of Canada, and I was still in practice, and I saw these attributes firsthand. Let me share with you one vignette from those days that illustrates these traits. I was appearing in the court on an administrative delay case. I was acting for the Human Rights Commission, and they had delayed rather a long time setting a hearing for the person involved. My opposing counsel was the very formidable counsel, the late Joe Harvey. I had lost in the Court of Appeals, so I was arguing as appellant. And I could see, or at least I sensed, that the court was somewhat divided on this particular case, judging by the questions. And it also appeared fairly clear that Justice Binney was on what for me was the wrong side of the divide. I plugged away and finished my argument, and then Joe started his, and of course was very powerful, as he always was. But he at one point strayed a little bit and overstated a matter from the record. And this is the point of the hearing that stayed with me for more than 20 years. I don't remember much more about the hearing, but he had overstated slightly, and I thought it was a material point. And so I started fumbling around my appeal books to find the reference that I was sure was there somewhere that would allow me to make a point in reply. When, as I started to thumb my way through the appeal books, I heard Justice Binney put a question to Joe, which was exactly with the page reference and the line reference, the point I'd been looking for, even though I'd been living with the case for a couple of years. I was rather hoping when I heard that question that it might mean that Justice Binney was crossing that divide over to my side, but alas, that was not the case. He was simply being fair-minded and making sure that we argue this case on the record. But it struck me at the time, and it has stayed with me since, that this degree of preparation and hard work and this fair-mindedness was the essence of top judges, and it's something I've tried to maintain since I've been on the bench as well. One other quality that Justice Binney was known for was his competitiveness, a quality that is not unknown to leading counsel. I understand that while he was on the Supreme Court, he would organize an event known to his clerks as Binney Fest, which involved, among other things, a pickup hockey game with his much younger law clerks and family members, which Justice Binney participated vigorously, and I am told played to win. Since his retirement from the bench, Ian Binney has remained active in the profession, particularly as a domestic and international arbitrator. He is one of the giants of our profession, and we are fortunate that he is here to give us his perspective on the early days of the charter.
Well, thank you, John, for that elegant but somewhat extended introduction. I have to say that his anecdote of my coming up with the page and reference merely indicates that you never know what judges are looking at when you're talking to them. You think they're looking at what you want them to look at. In fact, they're looking at what they want to look at. And it just so happened that Mr. Hunter and I coincided on that point. I have to acknowledge, as I did when the organizers told me that John would be making the introduction, that I would happily switch roles. John, for many years, was a member of what we used to call the Supreme Court Bar, which referred to maybe 10 or a dozen lawyers across the country who customarily appeared on all the big cases in the Supreme Court, and whose submissions, integrity, talent, research, and hard work were universally respected. It was an informal group, but John was certainly there. I just think that if he had hung on and practiced a little bit longer, he might have been the next judge directly appointed to the Supreme Court from the bar. But he compromised on the BC Court of Appeal, which on the whole is not a bad place to be. Now, I have been asked to talk about the Charter and Section 1 from the perspective of 1982. So today I am wearing my Department of Justice hat, slightly faded, still stained with tears and a certain amount of blood. And I look back at the Charter. I was appointed Associate Deputy Minister in June of 1982, and the Charter had come into effect in April 1982. And my responsibility was for all of the common law litigation for and against the Crown. So there was a large number of very fat files sitting on my desk when I inherited the Charter. And I'm going to frame my remarks today around what are commonly referred to as the 5 stages of grief, because I have to say that the early experience of the Department of Justice with the Charter were not all happy days. And the 5 stages are denial, anger, bargaining, depression, and resignation. Within the department, of course, there are 2 distinct groups. There were the policy people, who were those who really had conceived and formulated the Charter. The Deputy Minister, Roger Tassé, Barry Strayer, who became a judge of the Federal Court of Appeal, and a fellow called Fred Jordan. So the 3 of them essentially, went around the world picking up sections here and there, molding it into a coherent whole. And they were highly supportive of the department taking a view in its court cases that was supportive of the liberal and generous interpretation of the Charter. The litigation group, subject to the client's direction and interests, understandably took a more narrow view of the Charter. And the fact is that, difficult as it may be to believe 40 years after, it was thought that the Charter was not going to make a huge difference outside the criminal law. For a number of reasons. Firstly, it was seen as a political instrument. I mean, one wonders why it is necessary to refer to a part of the Canadian Constitution as the Canadian Charter of Human Rights and Freedoms. I mean, whose else would it be if it was in the Canadian Constitution? But Trudeau's idea was to identify fundamental values with the federal level. his view was that the provinces were essentially administrative units and that they had obtained far too much power, basically through the rulings of the Privy Council, echoed down through the years by the Supreme Court. So he was making a political statement about the charter, not a legal statement. You know, we relied, I think, on the composition of the Supreme Court. In those days, although they had bared their fangs somewhat in the patriation reference, there were still, judges, Martland, Ritchie, Chouinard, who had been instrumental in dragging the Supreme Court history and the Bill of Rights, although Ritchie wrote Dry Bones, which, the only case in 22 years where the Supreme Court declared inoperative under the Diefenbaker Bill of Rights. So it was a kind of stolid, conservative, lawyer-like group, not at all like what were seen as firebrands south of the border. Then the internal protections in the charter, which have been discussed today, one of which hasn't been, which is Section 7 reference to fundamental justice. That was understood by the Department of Justice, as given in testimony to the Joint Committee, to be a proxy for natural justice. It was a procedural protection. The judges were worried that if they used a phrase like due process, it would get all mixed up in the US jurisprudence. So it was the framers decided to go with fundamental justice, but it was not conceived to be this huge, vast right in which everything else is subordinated that it has become. It was thought, and I was interested in the discussion in the last panel about the proper role of Section 1, because in the view of the Department of Justice, and I think the view largely of the political people, Section 1, Section 33, formed together with the substantive right a whole. And what the claimant got was the net of what those three guardrails imposed. So that Section 1, as I think has been alluded to earlier, originally read that rights that would be generally accepted in a parliamentary democracy, or words to that effect. The demonstrably justified, came in, but it came in the context of a debate, which is, well, what would be a sufficient objective to justify the infringement of a right? And we were aware in the department of the Dworkin view of taking rights seriously, that a right could only be trumped by another right. But that was rejected. What the framers decided is that government values, public values, schools, hospitals, education, equality rights, all of these things were in the mix, and it would be a balancing act, not only of rights against right, but right against broader public policies that would be addressed in Section 1. As for Section 33, I think it was considered that the sovereignty of Parliament, what was a fundamental belief in 1980, 81, 82. The judges believed it as much as the parliamentarians believed it. It was seen as, in the words of Premier Lougheed, said, ultimately, elected people are more important than unelected people. And this was the view taken throughout the process in Ottawa. So my former colleague, Jack Major, was quoted in the Globe and Mail a couple of weeks ago as saying, well, Section 33 means the Constitution is like a boat with a hole in it. But there wouldn't be a Constitution if the hole wasn't there. The hole, the hole is as much part of the boat as the boat is. So that you have to think your way back into a mental perspective that valued enormously the supremacy of Parliament, the legitimacy of elected people. It was said, for example, derisively that the Charter represented an attempted transfer of power from elected Liberals to unelected Liberals, who were then festooning the federal bench. So that if you see Section 1 in that light, and Section 33 in the light in which it was conceived, I think you have a proper starting point. And, you know, when I say that the department did not expect any huge push from the Charter, there are really no additional resources devoted to the Charter within the litigation group. There's one guy called Graham Garton, who some of you may have come across, who was a brilliant lawyer. He was in charge of litigation involving the Charter and had a huge big binder of every Charter case that came in and would generate an analysis to be circulated. So one guy responsible for the Federal Department of Justice's lawyers across the country. I think we were persuaded that the so-called travaux préparatoires, the record in the joint committee in Parliament was very solid. They had received extensive briefings from Roger Tassé, who was a very widely respected, distinguished, brilliant Deputy Minister of Justice, and Barry Strayer, who was also a considerable figure. You know, we may not have had the graybeards of the American Bill of Rights, the James Madisons and so on, whose words echo down the centuries, but we had very bright people who were giving very logical explanations on the basis of which the committee made their decisions. So it was thought that going forward, that the Supreme Court would pay some attention, not be overwhelmed, but pay some attention to what had transpired before the committee. And don't forget, the committee was not overly into limiting rights. You know, Section 15, it's often forgotten, was proposed as a non-discrimination clause. It was the committee that said, no, we're going to convert it into an equality clause and install the four equalities, and then said, and in particular, without discrimination based on X, Y, and Z. So the Joint Committee was not at all minded, to create a weakened charter. If anything, it sought to extend charter protection, but it still believed in the sovereignty of Parliament and the balance of public interests, and that rights did not necessarily triumph over all. So stage two, we come to anger. And of course, the first order of business was the Supreme Court threw the travaux préparatoires out the window. The BC motor, I don't know why so much destructive litigation comes out of BC, but the BC motor vehicle reference, the Supreme Court was faced with its first big challenge to what Section 7 said. And extensive reference had been made in the BC courts until it got to the Supreme Court of Canada to Barry Strayer and Roger Tassé's explanation of what the section was all about. And, then Justice Lemaire said, these meetings aren't determined by a few public servants, however distinguished. Fundamental justice is not the same thing as natural justice. It just isn't. And informally, he used to give the example of, well, somebody comes up to you and hands you a lemon and says, have a pineapple. And you say, but it's not a pineapple, it's a lemon. And they say, yeah, but I told the House of Commons it was a pineapple. And he says, well, that's your problem. And so it was with the Joint Committee. That's their problem. If they want to mislead Parliament or the Joint Committee, so be it. But the result really was to throw out a huge body of work. And in the jurisprudence, subsequently, there was very little reference to the minutes of the Joint Committee. The second step in the stage 2 anger was a case which I argued, Operation Dismantle. And as most of you well know, Operation Dismantle involved testing the cruise missile in the Canadian Arctic and down the Mackenzie Valley. The reason is that there was so little topographical change in about 1,000 miles that it tested to the limit the cruise missile navigation capability, because it navigated by reference to things in the landscape of which there were very few in the Mackenzie Valley. And the essential argument was, this is a political question with a nod to the US jurisprudence, which carves out political questions based on the separation of powers and the responsibility that has to be taken by the executive in matters such as defense. And I went to the Supreme Court and said, the cruise missile, contrary to what is said by the disarmament group, this Operation Dismantle, is a highly complex weapon, and here's why it has to be tested and the way it's being tested. And it's all part of a treaty with the United States, under which Canada agrees as part of its contribution to make testing facilities available, and so on and so forth. And that ultimately the government is responsible for participation in treaties and so on, which are the defense of the country. And the government, if it takes responsibility, should have the right to make the decisions. And sort of under my breath, and how precisely do you expect to get the expertise to make those decisions on your own? And the answer from the Supreme Court is, well, there are no political questions exclusions. All sorts of political issues will be raised under the Charter, and we are not going to be deterred by our lack of information and expertise from deciding them. Justice Wilson said, the question is not whether we can do it, the question is whether we must do it. Whereas I was saying, well, if you can't do it, maybe it's an indication that you weren't intended to do it. But the declaration of the Supreme Court, she was a concurring judgment, but collectively, the court was very clear that there would be no equivalent in Canada to the political questions doctrine. So the Charter bound the politicians, and one would expect, therefore, that the Charter would bind the judges, equally exerting government power. And then you get, again, to another BC troublesome case, dolphin delivery, where it was suggested that the judges in exercising their coercive powers and adjudicative powers were also bound by the charter. And I think the federal government just intervened with a very light touch. But the position in British Columbia, which is quite right, was that if that position was adopted, all of private litigation would now be swept up in the arms of the charter. And the court was not prepared to do that, but they kind of wiggled out of it, saying, well, of course, yes, judges exercise power, the power of the state. We are part of the three branches of government, and in the political science sense, we're part of the government, but we're not really part of the government so far as the charter is concerned. So you then come to the decision that so much has been said about today in Oakes. Well, Oakes culminated a series of debates, some of which have been alluded to here. It was thought that the court would be very careful in balancing the substantive content of the rights with the remedial provision or the limitation in Section 1. If they were to give huge scope to the rights, then they would be careful to allow the government more scope for justification. For example, Peter Hogg said in Section 15, if there's a distinction and people are unequally treated, then you go to Section 1. So the thinking in government was, well, if that is the case, then they can't erect a huge barrier in Section 1 because the combination would be more burdensome than the system could permit. If every classification difference made by every statute, and that's really all that statutes do, had to be justified under Section 1, it would become impossible. But the court doesn't agree. The court talks about, and I won't go through it because there's a lot of discussion here this morning. They took what was essentially the decision of the European Court of Human Rights in the Sunday Times thalidomide contempt case and adapted it. They didn't refer to it, but that was quite right, because if you refer to some decision and it's subsequently changed, then you're on the hook. So, but the analysis seemed to fit. It was good. But the Supreme Court left out a lot of the nuances that the European Court had built in, such as the margin of appreciation, which was directly affected to, related to Section 1, because it allowed governments a certain elbow room in dealing with policy issues. The European Court called about polycentric decisions and working out social benefits and so on. None of that was brought in by Oakes. Instead, there was this really very high hurdle developed, which was added to by the decision in saying that, well, administrative costs and expense is really no object when it comes to justifying the violation of a right. The emphasis on evidence has been discussed here today. I think evidence is one of the really big problems with Section 1. These evidence cases are mega trials. Look at what happened in Carter on the assisted suicide. Who can possibly afford to participate in that kind of exercise, unless you've got the fundraising abilities of Joe Arvey and some of these, mega issues. But for the ordinary litigant to get into a Section 1 case is the end of it. If the government pours its resources in, how is it to be answered? How are you to get competing experts to go up against what the government can provide? When I was in the Department of Justice, we used to have a saying that we had the best clients in the world. They were stubborn, they were stupid, and they had bags of money. So if they really want to throw a Section 1 case, they can burn up months And it seems to me that that is a huge problem. And at the end of the day, how do you, for example, in a case like Operation Dismantle, reach a reasoned conclusion at odds with the government? And in the end, the court walked away from Operation Dismantle. They say, no, it's justiciable, but we're not going to adjudicate it because how is anybody to tell whether testing the cruise missile makes a World War III more likely or less likely? So then, can I told what time I'm supposed to end? Okay. It's now that I've got through the grief section, stage 3 is bargaining. And I'll give a few examples because I think as the charter developed in the early days, the court began to recognize that there were problems in some of these skywriting, banner, eye-catching decisions which they had been making. I think in terms of section 15, the court in effect rewrote what the special committee in Parliament had written, which is they took out the front end equality provisions and turned it back into a discrimination clause. So there was a recognition that it is simply not feasible for the judicial system to address every distinction made. For example, there was a case in Newfoundland, somebody injured at work, workers' compensation. I am disadvantaged because I can't bring a tort claim. I'm stuck in workers' compensation. Court says, quite right, you're differentially treated, and it has to be justified under section 1. The Supreme Court said, no, we're not going down that. We're not going down that road. So there developed a kind of what some scholars described as dialogue theory, where the court made some initiative and there was a response back and forth. And the court was no longer saying, well, my way or the highway. The court was saying, well, this is the view on the rights. And you come up with something and we'll look at it. And two big examples are the medical records of a complainant in a sexual assault case. O'Connor took a view that if the documents were reasonably relevant, then they should be produced. Parliament came up with a different view in a case called Mills and said, that's too easy. That doesn't sufficiently respect the woman's right to privacy. They should only be produced if it is necessary in the interests of justice. And the court, instead of saying, look, we told you that's not the right approach, the court said, all right, Parliament has resources the court doesn't have. Parliament can hold hearings that go on for weeks. Parliament can call witnesses from all over the country. Parliament has more than 9 people whose brains are working on the solution to this particular issue. Also, in the denial of bail, a case called Morales was very strict about what conditions a court must find to deny bail. In a later amendment to the bail provision, Parliament came back with a different formulation that had to do with the detention necessary for the administration of justice, and the court said, all right, I mean, we're interested in vindicating a principle. We've stated the principle. We acknowledge that there's more than one way of achieving the principled objective, and we are adopting, as Bill said, a posture of respect for what Parliament has to say. I think also the court developed some internal limitations, as discussed earlier, on the rights. For example, section 15, the Nancy Law case. was a clear case under the jurisprudence that this woman who was 30 years old, denying a survivor's, denied a survivor's benefit under the Canada pension plan because of her age, or 30 years old. So the court goes through a whole analysis and comes up and says, yes, but her dignity was not affected. Now, you know, logically, intrinsically, that's got to be right. The Canada Pension Plan survivor benefit was not really intended for 30-year-old women with no dependents and no children. But the logic of the earlier jurisprudence, if taken literally, would have gone elsewhere. So the fifth stage, acceptance or resignation. I think the Department of Justice concluded that you know, the charter was something that could be lived with. As people used to say, it could be worse, could be worse. They were resigned to the new breed of judges. You know, can you imagine Markland being replaced by Wilson? I mean, it is, I think, greater than Breyer being replaced by Amy Corrigan Barrett, you know, in terms of a switch, or Ginsburg and Gorsuch. I mean, this is a huge change. Chouinard, former deputy minister of Quebec, justice in Quebec, being replaced by Claire Ledubé. Ritchie being replaced by Laforêt. So, you know, although we estimated that the court would be conservative going forward, we did not anticipate the rapidity with which the court changed its guard. I think it was underestimated the extent to which the charter would gather huge public support. How people identified, as Trudeau had intended, this was the political intentions behind the charter, that people would think of themselves as rights holders, and they would identify those rights with the federal level of government. And politically, it has been a stupendous success. So my view, 40 years on, switching my justice hat to the judicial hat, is I think the panel, earlier panels today have, you know, the competing views have not really been mutually exclusive. I think there is still a lot of work to be done on the content of the rights. What I call the interrogation trilogy in criminal law, right to silence. I think the Singh case, you know, was just wrong. The man asked to be returned to his cell 17 times, and the police refused. And ultimately he confessed. Detention. If a policeman says to you, stay there, it can't be right that the court says, well, you have a right to walk away. Police have no authority to tell you to stand there. You're not detained, so you don't get the rights of a detainee. And the right to counsel, which has just been shifted in the last week by a Supreme Court decision called Dussault, which says, well, perhaps the earlier cases were a little too strict, saying that, well, you got this one call, and unless they up the charge or something like that, you have no contact with your, further contact with your lawyer. So yes, there is ongoing balancing within the rights. It's a very healthy thing. The court, you know, should draw on its experience going forward. I also agree that something has to be done with evidence. Some of the panelists called for more evidence, some less evidence. I ventilated a little bit on what I think the problems are. I think the Carter case, to me, not only is there a problem of the vast evidentiary burden, but the decision of the Supreme Court that the deference it will pay to the trial judge, not only in terms of adjudicative facts, where the deference has always been shown, but legislative facts. You know, what are the facts underlying the policies behind the legislation? And the Supreme Court in Carter says, we will defer to the trial judge on that, as well as the adjudicative facts. What does that mean? The whole case is decided by the assignment of the judge. You can assign a judge with a pretty good idea of what that judge's predilections are in terms of the issue. And once that judge has control of that litigation, the Supreme Court seems to be saying in Carter as well, all the way up, deference is shown. So you would have to show enormous error in order to set aside the policies underlying the court's decision that a charter right has been violated. So those are a few thoughts from 1982. I hope they've been of some help, and I congratulate the organizers on pulling together not only an interesting conference, but one that is hugely necessary to keep a fire lit under the judiciary to try and do better. Thank you.
Enriching, illuminating, and indeed, I think you've lit a fire under us as well. That's wonderful. So thank you so much for that. And it's a pleasure to have you here. Thank you for accepting our invitation. I wish we had time for Q&A with you, but the train has to keep going. This is where I feel very guilty as an organizer, having to keep things moving. But I also want to thank Justice Hunter for your very eloquent introduction of Justice Biddy. That was very, very well thought out and very well deserved. So please join me once again in thanking both Justice Hunter and Justice Biddy. And with that, we'll move right into our next panel, which is going to be basically, I think, focusing on Section 1 in the context of administrative law. We have, I'll ask our panelists, Carmel Dielman and Mark Mancini, to make their way to the floor, as well as our discussants, Jonathan Murniak and Christopher Kinzinger. As they're making their way to the floor, I will introduce them very briefly. We'll continue with our discussion today. So I'll start off with Carmel Dielman. She is counsel for the Provincial Health Services Authority of British Columbia. We also have joining her on the panel, Mark Mancini, who is a doctoral candidate here at the Peter A. Allard School of Law. And our discussants are Jonathan Murniak of Coon LLP and Christopher Kinzinger, National Director of the Runnymede Society. You'll notice on your program that we also had slated for this panel Professor Marcus Moore of the Peter A. Allard School of Law, but unfortunately he's unable to make it today and sends regrets last minute change of plans. So I will hand over, if the panelists are okay going in the order that they appear on the program, I think we'll go with that. And that would actually as kind of with Carmel Dielman. So if it's okay, I'll let you have the floor. Please feel free to come up. Thank you. Please join me in welcoming my next.
Well, thank you very much. I'm really excited to be here, and thank you to Derek and Brian for inviting me here today. So the work that I've been working on has been looking at the Doré framework in comparison with the Oakes test. And so the Doré framework has been utilized in administrative law. I think it was referenced this morning that the cases that proceed under administrative decision making, when it goes when they're trying to justify charter infringing decisions, they utilize a different framework than the Oakes test. And so my work isn't necessarily novel. There's been a lot of commentary in the last 10 years on the Doré framework, particularly in reference to the Oakes test. But I hope that my contribution is just to add meaningful discussion to this area, as it's really important, because the average Canadian primarily sees their rights largely impacted at the administrative level. This is where we kind of rub shoulders with the government the most in our daily lives. So it's really important to make sure that our rights are protected in this avenue as much as they are in traditional constitutional litigation. So the kind of the background is that my paper focuses on comparing the proportionality analysis between the two tests. And there's a lot of background academic commentary, judicial disagreement kind of on other aspects of DORE, in particular, the change in language to charter values, as well as charter rights, and as well as the onus under the framework. But I don't really get into that, and I can leave that to the academics who have addressed this in the past. And so specifically, I look at the 3-part proportionality test under Oakes and compare that with the one step that's utilized under DORE. And I argue that there's a twinfold loss in administrative law. One is that we lose robust protections guaranteed by Section 1, and 2, we actually lose flexibility in outcomes. And I think this is pretty ironic, given that these were the reasons why the court, they felt that a new test was actually needed, was to provide flexibility to administrative law, but I think we've actually lost that in the new framework. So in looking at specifically the 2 steps in the Oakes test, I'm not necessarily advocating for just importing the Oakes test into administrative law, although some people do advocate for that, simply leaving the DORE framework to the side and returning to the Oakes test. But as the DORE framework has been with us for 10 years, I think it's more prudent to assume that it's going to continue to be with us, but how do we infuse some of the similar considerations into the analysis? And so in particular, with respect to the rational connection test, which is the first step under the Oakes proportionality analysis, it's looking at this rational connection with a pressing and substantial objective. But when you look at DORE, all they ask us is to consider the statutory objective. So there's really no scrutiny of this objective. There's no step set out as to how we are to consider the statutory objective or what we're looking for. And so I think we're missing a big piece of the analysis when we do this. We're almost essentially accepting that the government's objective is valid and that the decision at issue is rationally connected to that without digging into that further. And I recognize that a lot of times this isn't a very key component of the analysis under Oakes itself, that it isn't a stage that the government often fails at, but I liken that to a stop sign at a quiet intersection. The stop sign is no less relevant, and the accidents it's designed to prevent are no less fatal than if it's a really busy intersection. It's still an essential component of the framework that I think decision makers and then reviewing courts need to stop at and consider to ensure that we aren't actually blasting through that intersection and that we aren't infringing rights unnecessarily. And then the second part that I look at is the minimal impairment requirement. And so I think DORE tries to give lip service to this. So in Loyola and TWU, they talk about affecting the charter protection as little as reasonably possible. So I think they're trying to get at this idea that if there are other alternatives, maybe we should take those into consideration when determining whether the infringement was necessary. But the court doesn't seem to actually utilize this very often. So in particular in Loyola and TWU, they say that they are considering whether the charter protection was affected as little as reasonably possible, but there's no analysis on that. The court really just moves straight into the balancing of the DORE test. And so this is where I argue about the loss of flexibility. And what I think we should be bringing back into the analysis is reasonable accommodation, which is actually kind of, it's an interesting one when you look at Multani, because in Multani, the minority decision, which Justice Abella formed part of, actually argued that it's reasonable accommodation that needs to be considered in administrative law. And she argued that minimal impairment should be separate under a traditional Section 1 litigation in traditional constitutional litigation. And so this kind of debate was carried over into DORE, the idea of what are the two different frameworks, or do we need two different frameworks in these areas? But in DORE, Abella seems to just leave alone the reasonable accommodation piece and doesn't go back to address it. And even Chief Justice McLaughlin had talked about reasonable accommodation and the analogy for minimal impairment. She talks about it in the Hutterite Brethren case. In Obiter, but she doesn't go back kind of in, her minority decision in Trinity Western when she's talking about minimal impairment. She again doesn't address reasonable accommodation. And I think that that's missing from the analysis. And I think it's really important in administrative law because separate from traditional constitutional litigation where we can't really have discussion with the legislature that is passing laws that's infringing rights, you can have a dialogue in an administrative law context, often with the administrative decision maker. So for example, in TWU, whereas they only saw the options as to approve TWU or not to approve it, I think if you actually were required as part of the analysis to consider whether TWU's freedom of religion could be accommodated, you have other broader outcomes that could be considered. So for example, at the end of the day, at the end of all of the litigation, Trinity changed it so that their covenant wasn't mandatory. And what would be an interesting thought is whether if the Law Society had said that from the beginning, like that will satisfy our statutory objective if you maintain your covenant, but you don't make it mandatory for students, it's a way that you could conceivably think how Trinity Western's freedom of religion might have been accommodated. You might have had dialogue. And you can also see this in Multani. So in Multani, the student and the school before litigation had agreed that the student could keep the kirpan sewn into his clothing. And it was the school board that said, no, absolutely not. There's no way that we will allow the kirpan to be on the school grounds. But you can see that this dialogue between the parties allows for other options to become available. And this is why I think that reasonable accommodation actually brings that flexibility into the analysis, which I think was one of the reasons why we thought we needed a new framework to begin with. And so kind of in conclusion, I think if we're going to have a separate framework that's uniquely positioned to fit the diverse needs of administrative justice, we need to actually ensure that it meets the goals for which it was created. And those goals being the robust protections guaranteed by Section 1, so that the DORE provides the same amount of protection as the Oakes test, and that we actually get this flexibility in outcomes so that the framework is able to provide protection across the broad array of administrative decision makers. Thank you.
All right. Well, first of all, just want to say thank you to Brian and Derek and CLF for hosting this event and for inviting me to be a part of it. I think CLF and what these gentlemen are doing is so important for our constitutional tradition and for intellectual diversity in the legal academy. And so I'm just so pleased to be a part of this. And I'm so pleased also for their allowance. I've been traveling for various conferences overseas in the last few weeks. And so my paper is very much a work in progress. So I appreciate the opportunity to be invited nonetheless. So let me put my cards on the table right at the front of this. I'm a fairly younger scholar, but for as long as I've been interested in this issue, I've thought DORE was wrongly decided. The framework, I think, is too loose. The emphasis on charter values too abstract. The proportionality framework, in my view, underpowers rights. But the question has always been, what replaces DORE? Justice Abella and DORE raises questions about the ability of the Oakes framework to work in the administrative law context. Practical problems do come up. But in this paper, what I'm arguing is that post the Supreme Court's decision in Vavilov, we now have some conceptual tools that we can use to implement the actual text of Section 1. And so in a way, Vavilov is a good doctrinal vehicle for us to use to get closer to the actual, what Section 1 actually says and what it actually promises in terms of our constitutional rights. And that's so in two ways. First, we know that, as we discussed today, Section 1 guarantees rights. And I think what Vavilov tells us is that a guarantee of rights, a guarantee of constitutional rights, means that courts have to take a more rigorous role on constitutional review. The Vavilov majority says that the Constitution applies to us all, and it's the supreme law of the land. And if that's so, that militates towards a certain role for the courts on judicial review. So that's the guarantee element. The second element of Section 1 is the need for demonstrable justification. And here Vavilov is really on point. Vavilov endorses a culture of justification in administrative decision-making. And so we might say that under a revised administrative law framework for constitutional adjudication, the reasons a decision maker offers for limiting rights turn out to be very, very important. And we should expect more from them when they decide to limit rights. So in my comments today, I'm first going to briefly recap an argument I made in previous work about why Doré was wrong. I think I have to do that first in order to move to my next point. And then I'll outline these two aspects of the new, what I'm going to call the new administrative law approach and what it will offer for us. And I think here I'm really very much benefited by all of the work that lower courts have already done post-Vavilov to flesh out the requirements of that decision, not only in substantial legal interpretation, but also in relation to constitutional issues. I'm thinking specifically of decisions in the federal courts system. But first, let me turn to Doré, and I'll breeze through this part pretty quickly. I think the fundamental problem with Doré, as I argue in a piece in the Dalhousie Law Journal from 2020, especially post-Vavilov, is the concept and the vision of the administrative state that Doré advances. Doré stands, I think, in a tradition of administrative law scholarship that I broadly describe as big P progressive. And I'm thinking of people like John Willis, previous scholars that were very optimistic about the potential for the administrative state to advance socially just outcomes, number one, and to be staffed by people and experts and men of good standing, quote unquote, that would lead us to the right decisions. This sort of faith in technical expertise that I think was long defining of the field. But we know that as a matter of fact, and as the administrative state has grown, the progressive view is rather myopic. And it's so because the administrative state now is not just the labor boards, and it's not just the human rights tribunals, and it's not even just arbitrators. It's as I point out in a lot of my work, it's frontline decision makers, it's immigration officers, it's prison officials, repressive state actors that really in many senses may have no incentive, no internal incentives to abide by constitutional rights, and may not be appointed or selected or delegated power because of any assumed idea of expertise. And yet the belief in Doré that simply because an administrator has policy expertise, that transfers over effortlessly into the constitutional realm, I think now is very much open to question and was probably doubtful when the decision was rendered. We know now that Vavilov confirms this view. Vavilov, paragraph 30, tells us that if we just defer to administrative officials because of this idea of generalized expertise, what we'll find is that we're not going to know for sure whether in a given case expertise actually exists or was relied on in reaching a particular decision or was even demonstrated in the reasons. And so Vavilov suggests I think a better approach to expertise that is more consistent with the rule of law, and that's that the expertise has to be demonstrated in the reasons. Vavilov also tells us that the reasons are very important. The reasons have to be directed to certain contextual constraints that govern an administrative delegation of power. So when a decision maker reasons about a legal provision and is trying to decide the meaning of that provision in their enabling statute, they're going to have to address the statutory text, context, and purpose. They're going to be, with limited room for error, going to be asked to adopt the traditional approach to statutory interpretation that courts adopt. We aren't going to expect perfection. We aren't going to strike errors simply because material errors, we need the errors to be material. But we are seeing a heightened bar here in terms of the reasons offered. And we can compare this to, say, TWU, where the majority only require that the law society be alive, quote unquote, to the charter issues at play. As the minority or the dissent in TWU pointed out, that's not what reasonableness review is about. Reasonableness review is not only about the outcome, but about the process of the reasoning and how we get there. And that is what Vavilov promises us. The argument here is basically that Vavilov overtakes Doré, and that what is good for the goose in administrative law is just as good for the gander in constitutional law, or perhaps even better. So with that aside, what could replace Doré? My approach is, again, tied to the text of Section 1. And this approach is not, I didn't make this up out of whole cloth. It's been applied now in a number of cases in the Ontario Court of Appeal. One is the Ferrier decision shortly after Vavilov was decided. Another, the Robinson decision, 2022 FCA 59, just recently decided, that splits the approach in this way. So again, the first element of the new approach should be related to the guarantee of rights. And on this front, we should expect a court to apply correctness review in defining the scope of the right. The onus here would be on the challenger to demonstrate why an administrative decision fails to engage with the purposive interpretation approach to charter interpretation. So what does this guarantee aspect of the test look like? Well, there's a few elements. The first is that it might be an obvious point, but it wasn't one that was pointed out in Doré. Where a decision maker fails to engage with a charter right, when it's been raised in submissions, that will automatically render the decision wrong in law. And that's simply because the submissions, as pointed out in Vavilov, really do indicate the scope of an administrator's inquiry and what the administrator must decide. And again, this was an approach adopted by the Federal Court of Appeal in the recent Robinson decision. Now, someone might say in response, well, this idea of correctness review and the guarantee of rights, why is that necessary or appropriate? So at this first stage of the analysis, I think it's important to note that what an administrator will have to do is define the scope of a right and whether or not a claim made before the administrator falls within the scope of that right. And so just like in Vavilov, where we see a decision maker having to apply the text, context, and purpose, the normal approach to statutory interpretation, we're going to ask the administrator to do the same thing in constitutional law. We're going to ask them to look to the propositive approach to constitutional interpretation that we see in the seminal charter cases like Hunter and Seldom, and that we've seen slightly modified in recent cases like the Quebec Inc. Section 12 corporations case. Here, the administrator is going to have to direct themselves to the text of the charter as the most important constraint on his or her discretion, the evidence in the record, and the relevant precedents. And again, all of this will be reviewed as a matter of scope of the rights. Now, the correctness review standard is important here, I think, because again, Vavilov says that consistent applications of the scope of rights is a matter of correctness review. It engages the role of the court to act as guardians of the Constitution. And so we should expect here that correctness review will flow. Now, part two, I mentioned of the text of section 1 is demonstrable justification. And here, what I propose is a bit of a modified Oakes test. We see here, we're going to see some deference built into it, but it's not going to be automatic or presumptive like Doré is based on generalized notions of expertise. Where the deference is going to flow is to the legal connection that the decision maker has to draw between a properly scoped statutory objective, which must fit within the administrator's enabling legislation. And the court will have to ask whether that decision was necessary to reach that objective, whether there were alternative measures or not available to the decision maker to reach that objective. My final minute or two, what I want to point out is that I just want to address one counter argument, and that's that this is way too extensive for administrators to do. I'm thinking here of Professor Daly, who says, we can't expect administrators to be carrying around loose leaf versions of Peter Hogg and Ruth Sullivan on statutory interpretation and yada, yada, yada. I have two quick points in response. The first is that this to me is the price of delegating power. The price of delegating power is that we're going to have to expect administrators to abide by the law, just as we would expect courts to do. And in doing that, we are going to build in some deference. Again, the reasons aren't going to need to be perfect. We aren't going to expect every error to lead to a decision being overturned. But when a legislature chooses to delegate power, they should be held to the same standard as they would have if they made the decision themselves. They shouldn't be able to run or do a runaround around the law by merely enacting delegating provision. The other question is just the pragmatics of how a decision maker can do this. And again, I'm going to reiterate, the reasons don't need to be perfect, and materiality is going to play a big role here. If an error made in an administrative decision isn't material, in other words, if the decision could still stand in absence of that error, then we don't need to overturn the decision. So I know there's going to be lots of time for discussion, but what I do want to say is that I just want to end on the note that Doré, I'm not the first person to criticize it, and I won't be the last. And I expect and hope that with Vavilov, new tools for thinking and reimagining Section 1 will help us to come to a better approach on this topic. So I thank you for your time, and thank you again to Brian and Derek.
Appreciate it. Jonathan, would you be okay to lead off and discuss it?
Yeah.
Finish with Chris, sure, we'll have an open discussion after. So Jonathan.
Hi, so I just have some questions and a little bit of commentary, mostly questions. I'm reminded what Carrie Frock said earlier, that the Supreme Court never admits when it's wrong. And on that sort of note, I noticed that in Carmel's paper, she mentions that the Supreme Court's not implementing the Doré test as intended. And as a result of that, you proposed reasonable combination should be considered along with the test. So I guess my question would be, is this inherent problem with the test itself, or is it just more a structural problem with perhaps the Supreme Court not admitting that, you know, either it made a mistake or it wasn't as well fleshed out as it could have been?
Yeah, that's a great question. I mean, I think I don't like Doré, so I think I would say that the framework itself has a lot of problems, but I think that we could kind of import things into the framework. You know, the language where they talk about how it could to be as affected as little as reasonably possible. Like, I think if they flesh out the bones of the framework that they've given us, that it could hopefully meet the needs for which they created it to begin with. But so far, I don't think the Supreme Court has done that. I think the lower courts have often done that. I think the lower courts, like specifically, I'm thinking of the cases that followed Greater Vancouver, which was to deal with advertising on transit in municipalities. Because Greater Vancouver was decided prior to Doré and was dealing with transit policies, it actually looked at Oaks. And then the lower courts often, when they're looking at facts coming up now after Doré, are still bringing in some of this analysis, because I think Greater Vancouver did it. And so I think sometimes the lower courts are actually utilizing Doré in a more fulsome way. But I wish that would come, I think, from the Supreme Court, that there'd be a little bit more structure put on, or more flesh put on the bones of Doré, if that makes sense.
Yeah. Mark, do you have any comments on that?
Yeah, I one counter argument I often hear is that, well, Doré says one thing, but what the Supreme Court does with it is another. And one related to the point you raise is, well, you know, maybe the proportionality framework is working out to be quite rigorous. Anyways, I think that's hit or miss. I think I mentioned TWU, that wasn't a very rigorous approach at all in my view. And so I think if the argument is that the practice of Doré is rigorous, then I would just simply say that we should bring the law and what the statement of the law is up to date with the practice. And if that means changing what Doré looks like, I think that's the principled answer here.
Okay. I just have one more question. It's a little bit more of a longer preamble, but in Doré, Justice Abella stated that administrative decisions are always required to consider fundamental values. And of course, in Trinity Western, the BC benchers had ratified the popular vote of the Law Society members to deny Trinity graduates entry into the Law Society membership. At the BC Supreme Court level, Justice Hinkson stated that the Law Society of BC had the constitutional obligation to consider and balance those interests, but there was no evidence that they did so. At the Supreme Court of Canada level, the majority, on the other hand, seemed to skip over that and just kept on referring to, well, it's the reviewing court's job to consider those values, I suppose, not the administrative decision maker, although it didn't really say that. It said by omission. And then, of course, since Trinity Western has been decided, particularly I'm thinking of the BC Court of Appeal, there's been a number of decisions where a failure to consider and recognize those rights have been actually held decisions to be unconstitutional for that very reason. So my question for Carmel is it necessary for decision makers to actually apply the Doré or whatever administrative framework when they actually make the decision at the time they make the decision? And then my question for Mark is a little bit more specific. In the Trinity Western example with your need test for with inclusive of reasons, how would the Law Society do this when it was the members that voted to deny Trinity graduates? And it was what Chief Justice Bowman said was the largest tribunal in BC that made this decision.
Can I go first?
Yeah, go.
Okay, yeah. This is, well, I think, I don't know where to start with this. There's so many things to say. This is a question that arises all the time in administrative law. It arises with reference to maybe in a less extreme way, but in relation to municipal decisions where councils adopt bylaws, and we have to figure out how do we review this bylaw in absence of reasons or in absence of a process that leads directly to reasons written on a piece of paper. Vavilov here, I think, leads the way, and in both what it says and how it's been applied. So in what it says, it suggests that even in absence of formal reasons, we need to look to the record, and we need to look to what the decision maker did, the history of the proceedings, the history of the submissions. It's not going to be a perfect exercise, and it's not going to be mechanical, but we do need to see and look to see the record, to see what the decision maker actually did in considering the constitutional issue. My issue with Doré, or with TWU rather, is simply that it just said that it was alive to the issue of the charter being implicated, and being alive to something might as well not be alive to it. It doesn't seem to mean much to me. I think what Brown and Cote say in dissent is far more satisfactory, in that we should expect at least the record to disclose some sort of consideration of the stakes that are here, that are at play. And just a word about post-Vavilov, what's happened. This same thinking has been used to strike down municipal bylaws here in BC and in other provinces post-Vavilov on the basis that the record simply didn't disclose any consideration of the substantive legal issue. These weren't constitutional cases, they're just SAT interpretation cases, but we might think the same thinking applies.
So maybe this is, I'm going to put my lawyer hat on for just for a minute. So on the Trinity Western example, particularly where it was, a vote of the members, and the next day on October 31st, the benchers just say, okay, we're going to do what the members say. What might have, if you were the Law Society, what would you have done, I suppose, to justify that?
Well, I think the Law Society probably has to set up a separate process, a different process. I mean, this again is the price of delegation. If we're going to have, like, the Law Society is a sort of sui generis decision maker in a lot of ways, but if this is how we've decided to regulate this particular area, this is the price of doing it. The Law Society may need to establish a different process to manage these sorts of disputes and demonstrate to a court, thinking that these decisions might be judicially reviewed, demonstrate to the court that it was balancing or considering these rights. Now, I think here, this is why demonstrable justification is going to build in deference, because we can't be prescriptive about what that process might look like. But we need something more, I think, than just a vote or without any sort of substantive consideration. Again, price of delegating power.
Yeah, and I mean, I think I would piggyback on that for my answer, but I would say, yeah, I think that the decision makers, they have to at least turn their mind to these considerations. And like was already said, the reasons themselves might not be well formulated. It might not be the Human Rights Tribunal setting out a 20-page decision, but I think they do have to actually turn their minds to consider these. And I'm going off the top of my head, so I might be wrong, but I think it was a federal court decision, and I think it was called something similar to Abdi, and it was about immigration. And they said essentially, like, we can't defer to nothing. And I mean, I think Trinity Western was the court deferring to nothing. There was no reason that had been provided for the subsequent decision from the Law Society. And so I do think that the Doré analysis is something that needs to be considered in some fashion by the actual decision maker themselves.
Thanks both for the drafts and the presentations. They're both excellent. I really look forward to reading the final papers, and thanks again to the organizers for hosting such a tremendous event and for inviting me to ask a few questions on this panel. Before I get to my prepared questions, I actually just want to pick up, Carmel, on that point that you were just talking about administrative decision makers needing to turn their mind to the charter issue. And I'm wondering if you, and for both my questions, I'll pose them to each of you specifically, but I'd love to hear the others' thoughts. How do we assess turning of the mind to the charter in a way that doesn't become rote and formalistic, so that it doesn't just encourage decision makers to cite the applicable charter entitlements, to say the magic words and then say, see, we turned our minds to it because we talked about it. How do we get from that to actually meaningful substantive engagement with the charter entitlements that are at play?
I think that's where I would say that reasonable accommodation is important, where you actually have to sit and dialogue with the party that's coming before you and say, this is the right that's being infringed. What does that look like? How do we accommodate that? And so I think, you see that in a lot of the cases. And I think if you look at, obviously Maltani was a really good example of that. But I think you see it in other contexts as well. So if you have, you have parents at a school that don't want their kids to sit on a certain class, that I think that's the time where the school board has to sit with the parents and say, kind of what do the parameters of your freedom of religion look like, and what can we do to ensure that we're meeting our statutory objective and your freedom is being, we're not infringing on your freedom unnecessarily. And I think if you add that component to the analysis, and it might be at the end of the day that there's nothing they can do, or the other party might not be willing to engage in that discussion. But I think on judicial review of that, if the decision maker can show that they tried to have that conversation and these are the considerations we were making, I think it would go a long way to show that they turn their mind to it.
Yeah, this is a great question, Chris. Thank you for it. It reminds me, I'm in the process of working on a paper just simply called Boilerplate. And it's about how how courts post-Vavilov are reacting to decision makers. You're simply saying, I've considered all the factors. Here's the law. I've considered all the factors. This is my decision. This happens. It's impossible to tell how frequently it happens, but it certainly happens. Immigrant visa decisions, it's common. Post-Vavilov, courts have been pretty worried about this kind of thing. And I think that the device of using reasons and focusing on the reasons really helps to heighten the standards so that we aren't going to fall into this. So case of the Nova Scotia Supreme Court on a habeas corpus decision, which is subsumed under reasonableness review. The court says, well, we can't just say, the decision maker just can't point to say, well, look at all the things that I've considered, here's my result. There has to be a chain of reasoning that's connected to the law, connected to the facts, and connected to the evidence, and the court has to be able to follow that chain. And if they can't, then unfortunately, again, we can't defer to nothing.
So Carmel, I'm going to start with a couple of questions for you. Mark, I'd love to hear your thoughts. Mark, I have a few questions for you as well. But Carmel, going back to kind of the first stage of your proposed reframed Section 1 test for administrative decision makers, I wonder, are there potential unintended consequences of the way that you propose merging the pressing and substantial objective stage and the rational connection stage into a single determination? And I wonder whether, one of the impulses that we see in administrative law is to recognize that administrative actors in particular are at risk of exercising otherwise valid or pressing and substantial authority in an arbitrary way, which seems to be what Justices Brown and Cotier are concerned with in Trinity Western.
So I'm not sure, tell me if I'm not really answering your question. I think kind of when I propose doing that, it's more from a practical lens, that the proportionality analysis in Oakes only looks at rational connection, and pressing and substantial is outside of that. And so in comparing the two, I'm bringing both in so that I can kind of analyze pressing and substantial under the proportionality analysis as well, and then trying to import that into the Doré framework. I'm open to hearing critiques on how I think there might be unintended consequences to that. I do think that it's something that you can look at together when you're, and I think oftentimes you see it, you know, like Justice Rowe, for example, in Trinity Western, when he's critiquing the majority's decision on how they didn't address either pressing and substantial or rational connection, he kind of analyzes it together. And so I think you can do that, but I'm not saying that there might not be unintended consequences. And you know, that's something that I can think about kind of going forward. I do think that it is an interesting point, and I think I would like to highlight that with as far as arbitrariness, that I think that this, and I'm not sure if this is actually really getting to your point, but I think to highlight kind of in my research that I think actually enumerating these and expecting the decision maker to address the rational connection with the pressing and substantial objective goes to the issue of arbitrariness in administrative law. And Justice Lowers had done a really good article, and he kind of talks about the psychology of judging and confirmation bias, and judges starting off, or decision makers starting off with a hunch and then trying to get to their conclusion. And I think kind of having these set out steps goes a long ways towards helping prevent that arbitrariness, because the decision maker actually has to consider all of these factors when they're going through. And the idea being that, you know, we need the rule of law, and even though it might be a bit cumbersome on your decision makers to actually